Welcome to Looking at Legal Stuff. Today we have 11 hearings in a case with a couple who have been in a 2-year-long custody battle that include accusations of DV, SA, and have included 3 CPS investigations that have led to Dad being unable to currently see his children until the reunification counsellor allows it. In addition, Dad defied a court order not to sell any assets by selling the couple's food truck. He then defied a second court order by only putting half of the $60,000 in proceeds from the truck in trust. Despite this greedy and entitled behavior, he tries to get the judge to give him even more. Let's see what the judge will have to say.
Dean Roberto Gall, and Mr. Gall is present. I see that he's here. Welcome to both of you.
Good morning.
And good morning. And Ms. Winkles, are you? It looks like you're online also, correct?
I am here, Your Honor. I am working very remotely in a different country. My internet is a lot spottier than I thought. So I'm going to keep the camera off just so that I can have the best connection. But can everybody hear me? And is it clear?
I can hear you great. Ms. Margraf, any issues?
I hear you fine, Ms. Winkles.
So we're here for a couple of different things. So first off, that one, we can maybe just address the first. There's a motion to waive mandatory settlement conference. That's brought forward by Ms. Winkles. Ms. Winkles, do you have any comments on that?
Yes, Your Honor. We actually signed an agreed order. We got it over to the court last week. We're all in agreement that it's probably appropriate to waive that mandatory settlement conference. And Ms. Margraf has also signed off on that.
That's correct, Your Honor.
I have that order here, so I will sign off on that. That seems appropriate.
And just so Your Honor's aware, just for the record, my client is also present in the court today.
Oh, okay. Thank you. I apologize. Ms. Gall, welcome. Sorry for that oversight. And then the next motion, it relates to the motion to rescind or modify the restraining order and also presentation on the restraining order. So from what I understand, there is the restraining order that was heard some time ago. Mr. Gall was not present due to one issue or another, and the court entered a restraining order, hasn't been reduced to writing. It's on today for that, and also a motion brought by Mr. Gall via Ms. Margraf to rescind or modify that. That's my understanding why we're here today. Ms. Margraf, Ms. Winkles, is that your understanding why we're here today?
That's correct, Your Honor.
Okay.
That's correct, Your Honor.
Okay. All right. So I have the proposed restraining order here. So probably would behoove us to address first the motion to modify or rescind that. If that's granted, then we can talk about the modification of it. If it's not granted, then we can talk about entering that order as presented. So, Ms. Margraf, you're the moving party related to that motion. So I'd invite your comments, please.
Thank you, Your Honor. We'd like to note for the court, first off, that the allegation that there was an exhaustive investigation via CPS was actually incorrect, and that is the basis for why it is currently being appealed. And while it's pending, we really would like to note that there have been 3 investigations so far, essentially, and that 2 of them have found that Mr. Gall did not molest his daughter. We feel that, in fact, the polygraph is a fantastic example. The man who administered it has decades of experience and found conclusively that he was not lying. Mr. Gall was not lying when he said he didn't do what Ms. Gall accused him of doing. At this point, we feel that Mr. Gall has fulfilled every single thing asked of him by the court, by Ms. Winkles, and by Ms. Gall. And at this point, anything else is simply overreach. And we're asking that the restraining order be rescinded. He needs to move forward with working with his children to repair their relationship. And this has been interfering without question in that progress. We've submitted reports from Elizabeth Rosen, who was manning the effort to reunify the children. Some of the records actually submitted by Ms. Gall herself indicated otherwise in terms of how awful the experiences have been. There was one note in particular where Caleb noted that his father had become irritated because some papers had been damaged, and then told the counselor at Columbia Wellness that, in fact, in the olden days, it would have been a huge explosion, and he had made significant progress in the way he addressed it. We'd like to ask the court to rescind the restraining order and permit Mr. Gall to progress with his work with his children.
Ms. Margraf, thank you. Could I ask a question? It seems like part of the motion is related to notice. As far as that hearing that Mr. Gall, it seems to be the position is that there is either improper notice or insufficient notice for the hearing in which the order was entered. Is that part of your motion also?
That is part of the motion. The notice he received had something crossed out with an incorrect docket on it. And we actually, Mr. Gall, before I represented him, submitted materials showing that he had waited on the wrong docket for the entirety of that hearing.
All right. Thank you. Yeah, I've looked at the case pretty closely. I looked at the notice issues fairly closely and dived deeply into the other issues that you've addressed. So I appreciate your input. Thank you.
Thank you, Anna.
Ms. Winkles?
Yes, sure. In a sense, I'm still, so I'm hoping everybody can hear me. During all the restraining order first, it was an interesting case in that the majority of the visitation was handled on the domestic violence protection order docket. And that was decided by the court. That wasn't Mr. Gall's former counsel or myself. That was just happened to be what the court decided. Actually, we attempted to set it on that docket. The court said that they would prefer it to be back over to this docket now. So we did set that. Everything on that docket minus one place that was crossed out said that the correct docket was the docket we were serving, the docket that we were actually on. Order the docket notice that we presented to him. We obviously had met and sent that to him. So I'm not sure why when 9 things said the correct docket and 1 thing was crossed out and said the incorrect docket, why Mr. Gall would choose the 1 out of 9. And I've given Your Honor a significant exhibit showing that. But in any event, just arguing the case again, this is a very delicate case in which I think the guardian ad litem here is probably the most useful person. My client is purely trying to protect the children from harm that she has been put on notice. And just to go back, these parties were married in 2012. They have 2 children. One is a little girl that's 10 years old. The other is a little boy. There has been extensive counseling in this in which my client is not present for that counseling. During that counseling, and you'll see from the medical records, the children have disclosed a series of essentially horrific violence that they have and or endured during their childhood, causing the children to actually have diagnosis of post-traumatic stress disorder, both of them. One of them self-harms, that would be the little boy. We then have children disclosing that they're afraid to see their father. They're afraid to have contact with their father. They disclose in one of the counseling records that they're willing to do it because dad just got a new dog. They're afraid for that little puppy's life. They're willing to essentially put themselves at risk because dad promises not to hurt the dog. That in and of itself is traumatic for a third party to hear. It can only be described as horrific for a child to have to make a choice over their own feeling of safety or the safety of an animal. There has been extensive counseling done with these children. Mom wasn't present. Guardian ad litem did have some involvement in that and has spoken with the counselors. The thing is that when CPS delivers a founded result for sexual assault, that has to be taken seriously. Now, whether there's an appeal in place or not, at this point, we have a child that disclosed it. We have a CPS finding of it. And we have essentially a 10-year-old little girl that we don't know. Frankly, mom doesn't know if it happened or not. And we are appreciative of dad getting these sexual history polygraph. Absolutely. As the court is this is a case where we have 2 children disclosing quite a lot to counselors where mother isn't present. The guardian ad litem here has had interactions with those counselors. The problem here is not that mom is trying to withhold, that mom is trying to keep dad away. The problem here is that we had a little 10-year-old that disclosed abuse. We did have a CASA investigation where a 10-year-old essentially said nothing, neither negative nor positive, essentially not stating anything about it, whether that was trauma for her at the time or not, and she just didn't want to talk about it either way. We don't know, but we do have a CPS finding of sexual assault. And while we are very thankful that dad took a sexual history polygraph, we have to be cognizant of the reason why they're not normally admissible in court. They're definitely a tool used by the guardian ad litem, but they're not admissible because they're not accurate. And by that, I mean, There are many times that comes up false positives, many times that come up false negatives, which is why we can't use them in criminal. We can't use them in family, really, because of the fact that they can be so faulty. And what we have here, dad may be appealing CPS, but what we have here is a CPS finding of assault. We have a DVPO that was granted after a full hearing with witnesses, with live testimony, with everything that was granted, that said dad did, dad did abuse mother and children, and that is significant. We then have a father that comes on, and while he's walking the walk and doing the counseling, comes on to the majority of hearings and states that it is mom that is the abuser and dad that is the victim, and then uses, the rest of the time to talk about how the judges and the lawyers are out to get him. This is concerning. And right now, the only thing that needs to be done is to protect the children pending either the appeal of CPS or pending a full hearing or pending a trial. While dad's relationship and his bond may be decreased in that time slightly, the fact is the overall necessity to protect a child from A, direct contact leading to more sexual assault, or B, indirect contact via the telephone leading to trauma is far more significant, and the benefit of that protection far outweighs the need for dad to have contact in the interim. My client is just doing her darndest to protect these children. She's already known that the DV happened. She's concerned that if CPS made a finding, that we have a problem. What we would ask for today is to have the guardian ad litem talk. That is the greater issue here, is to allow these children somewhat of a voice, and the GAL is their voice in this hearing, in this trial. So really, to protect these children, we need to know where they are mentally, and if speaking to dad, because right now he really just had the reunification and he just had the telephone contact. If that is true traumatic for these children at this time, what can we do to protect them? So I'd ask your honor, rather than talking to my client or having me continue to talk and argue, because really the GAL is the best person suited here to state what's happening and to state where these children are and what's needed to protect them.
Thank you, Ms. Winkles. We'll turn the time to Ms. Corey, and then we can hear from both Ms. Margraf and Ms. Winkles again after hearing from Ms. Corey.
Good morning.
Good morning.
I have been slightly removed from this case for some time, since I concluded my investigation, but I have kind of kept my finger in, I suppose, and followed it. I'm fearful of the CPS findings, in that if these children, and both of them, were to resume their visitation with Mr. Gall, that would be considered a failure to protect by CPS. And without that appeal to that finding, I just can't imagine re-victimizing these children in that way. I believe that further input is needed from Mr. Gall's counseling, from the children's counselors, and from CPS. But as you know, it's difficult sometimes to get information from CPS when it is a currently open investigation. And my report actually did not reflect that final finding because of that. It only reflected what was found previously. I did not have the opportunity to consider that finding in my final recommendations. As to the older son knows about these allegations toward his sister. His sister disclosed to him at some point many months ago. Not sure about the time frame exactly. He said while they were living with the grandmother. And it is as likely disturbing to him as it is to the younger child. Again, the most concerning thing to me really is the aspect of it being failure to protect if this is allowed.
Thank you, Ms. Corey. Ms. Margraf?
Thank you, Your Honor. First, I'd like to note again that all of the more disturbing allegations earlier in the counseling, they all occurred before reunification. And since then, again, there has been outstanding progress. We'd also like to note that this entire issue revolves around a single allegation about a single incident. And there's also a medical history of this child having hygiene issues. And at one point, Mr. Gall had to apply a medication. We believe that in the stress and chaos of leaving the family home, that's how this allegation bubbled up. And I would also note, Ms. Winkles is the person who requested this polygraph and then turned around and then also requested a forensic interview. We noted at least 2 have already occurred. Neither one was especially dispositive. We don't think a third would be helpful. Again, we are only asking that Mr. Gall have supervised contact with his children because he hasn't spoken to them for months. The situation is unquestionably difficult. This was an extremely unhealthy marriage, and I think everybody has come out of here with some damage, but Mr. Gall has the right to move forward with trying to heal that. I'd also like to note that CPS, again, did not follow their own protocol when investigating this. I think Mr. Gall has shown himself to be a person who can be around children at this point. We don't have any kind of solid substantive issue that shows that Mr. Gall did this. We do believe that Ms. Gall is interfering with him seeing his children. We're asking again that he be permitted to have contact with them again.
Ms. Margraf, were there 2 CJAC interviews or just one?
There was a forensic interview with the Kelso Police Department, and I believe an interview with CJAC.
Okay. Okay. All right. And then, so your request is that the reunification efforts continue and be guided by the reunification counselor?
Yes, Your Honor, that's correct.
Okay. And then Ms. Corey, do you have any input related to that specific request? And then we'll hear from Ms. Winkles.
Related to the request to begin reunification counseling again?
Right.
I think that maybe should be up to Ms. The counselor.
Ms. Rosen?
Ms. Rosen?
Yes, thank you. Sorry. I think that should be up to Ms. Rosen.
Of whether or not she feels that it's appropriate to continue to do so. Is that your position?
Yes.
Okay. Do you know what her position is on that?
I do not.
Okay. Ms. Margraf, your client, Mr. Gall's raising his hand. Any concerns if you were to share some thoughts?
I think we ought to wait, or can we go into a breakout room?
Yeah,
that's
yeah, it is. It is. I can place you and Mr. Gall into a breakout room and we can come back and.
Your Honor, it was just to answer your question. That's all.
Oh, Ms. Margraf, do you feel comfortable with him answering that question?
Ms. Rosen?
Yeah, that's correct.
Sure.
Okay.
So Your Honor, Ms. Rosen has been in touch with me every other week and just waiting to get updates about this court matter that keeps getting delayed. And she's looking forward to restarting reunification counseling and is keeping her schedule open.
Okay. All right. Thank you. Ms. Winkles?
Yes, Your Honor. My issue with having it be with Miss Rosen is twofold. Number one, part of our request was to request a reunification counselor closer to mom. The reason for this is that essentially mom lives obviously in a different area that's several hours away. Mom has to put both kids in the car and drive for, well over 2 hours to get to Miss Rosen's office. Mom makes essentially just a little bit more than minimum wage. Mom receives, very, very little funds in order to support the children or the family. And in fact, mom's attorney fee judgment still hasn't been paid. Mom is essentially put tasked to not only provide financially to get down here, but also just the time involved and the expense, and it conflicts with mom's work schedule. And so we have this issue. And so what we were requesting was, if there was reunification counseling, that it take place close to mom. The reason for that is the party that is essentially caused the need for reunification is that there's a DVPO against dad, and that is the reason. So if the court is entertaining reunification counseling, we would ask that, although it be slightly a little bit more difficult, maybe cost another, session that wouldn't normally occur, that it be with someone closer to mom. That way the children are not in the car for 4 hours out of the day after they're having something that may very well be a traumatic incident and then being essentially schlepped back and forth. Additionally, Ms. Rosen didn't have any information about the CPS finding, and that needs to be taken seriously. CPS obviously found something. Whether or not their investigation was valid, that comes out after a separate hearing, a separate administrative hearing, where they make that determination. To just state that it was wrong without having that finding of that they did it incorrectly, when we don't have any of their notes, we don't have any of their investigation reports, we have nothing like that, I think is very premature. There has been there has been deep findings of physical violence, but while dad is in counseling and reunification, the children during that time to the counselor, their private counselor, has stated that they are fearful of that, and they come away from that still being afraid. That in and of itself is a problem. And the fact that the reunification counseling records don't note that, but she only sees who she sees when they're with dad, which may very well be separate from their actual responses to that. So my concern is that we're really kind of doing these children a disservice without allowing their voices to be heard through their counseling notes. And that's why we submitted them to the court. So my client would ask that we await the appeal from CPS. That way we know that child's protected. If Your Honor is inclined to do telephone visitation, then maybe it occurs while the children are actually with their counselor, and not with mom, because that's a whole other issue. And if we're going to do reunification at all, that it be near mom, and that it be an agreed reunification counselor that's somewhere by mom. I'm sure we can find somebody. Lacey is up there. It's quite a large area. I'm sure that there are people available that we can get in to see very, very soon. But my client is very concerned, and CPS, their reaction is concerning. So we'd ask Your Honor to allow the restraining order to stay in place as it is. And if Your Honor is going to change it, that you change it to make it so that it protects the children in the utmost way possible. Thank you.
Thank you. Yeah, one question I wanted to ask either counsel or Ms. Corey can answer. How many sessions of reunification counseling have occurred? Not necessarily together or just individually, with Mr. Gall or with the children. What's the approximate number we're looking at as far as that have happened?
I think my client could answer that.
Mr. Gall?
Yes, Your Honor. We've had between 10 and 13 sessions to date so far. And the reunification counselor's note the last time was that the sessions would be a lot less than she anticipated because of the amount of progress that had already been taking place. One more answer.
I'm going to object. I'm going to object to that last statement, Your Honor, because it's hearsay and we have nothing in the record that supports that.
Happy to provide my reunification.
So the objection is noted, and it's
Your Honor,
sustained.
One more thing. With regards to the Ms. Winkle's last statement, I do want to update my attorney with a response to that, as she is newer to the case. So maybe a breakout room might be merited, or if I can just make a statement.
And Mr. Gall back, and Ms. Winkles, are you still with us, Ms. Winkles?
I am, Your Honor. And I also, just because Mr. Gall did have the chance to speak, I did speak to my client as well briefly. And so I'd like to add a little bit to this concerning Ms. Rosen as well.
Okay, if you want to lead out, then I could hear from you just briefly on your client's input related to that.
Okay. Yes, Your Honor. After speaking to my client, she has a few concerns about Miss Rosen as well. In the original order, the reunification was supposed to be child-led versus counselor-led. And the reason for that was because of the trauma and the abuse that was disclosed by the children. Miss Corey had an active role in that as well. It appears that that was not what happened, and that the children themselves were actually informed by the reunification counselor that they would be seeing dad no matter what, and that it wasn't their choice. My client has a significant issue with that because, again, we're dealing with trauma here, and we're dealing with children essentially taking their agency and power back and feeling safe. My client stresses again the need for a different reunification counselor that will actually apply what that court order says, that is child-led reunification counseling based on when the children feel safe, not when the counselor deems them to have actually been prepared. We'd also ask that Ms. Corey, should she need additional funds, and I'm guessing that she will, considering how much work she's put into this, that Ms. Corey be actively involved in that reunification counseling. My client is willing to find a way to come up with any funds, her proportional share of that. Like I did say, she does make very, very little, but she's willing to do anything to protect these children. She would ask that if any reunification counselor, that Ms. Corey have an active role in that. And again, that maybe Ms. Corey be reappointed with or be given additional funds for that work. And that's where she's at on the reunification counseling.
Your Honor.
Thank you. Ms. Margraf?
If I could directly address that, so you're saying basically that Ms. Gall said that her children said these things about Ms. Rosen. Wouldn't that qualify as hearsay and shouldn't be considered? Basically, but to circle back, basically, one of the conditions of relocation was that the reunification counseling would be continuing in the Kelso Longview area. And beyond that, we do have a lot of concerns about the idea of ending reunification with Ms. Rosen. There's concerns regarding the just one session costs. I don't think that's true. I think there's going to be a request for a significant kind of advanced fee deposit, and Mr. Gall cannot afford that. Setting back to square one after months of successful progress with a brand new person. And finally, I'd like to note, Ms. Rosen does know about the findings of CPS. I informed her of that in February. She is aware of what's been going on with CPS. So we are asking the court not to consider the option of moving reunification counseling closer. And further, I'd also note that there is a schedule where 1 week is a session via Zoom and 1 week is a session in person. This is not 4 times a month coming up and down the corridor, which we agree would be a lot. So we are asking the court to permit Ms. Rosen to continue in that role.
Okay, all right, thank you. All right, so the issues presented here are exceptionally sensitive and important to all the parties, and especially to the children. So I want to just first address the notice issue related to the initial hearing, which was had where the order was entered. So I'll just tell you my takeaway from digging into that. I think that the clerk's papers 104, which is the notice of the hearing, it could cause a reasonable person to be confused. I think there was the indication that it was going to be on a single document. It indicated that it would be on the protection order docket, and then the other page said it'd be on the family law docket. So on those 2 dates, there were, on the one date, there were both dockets were happening. So I think a reasonable person could easily be confused by that. And it looks like Mr. Gall had made attempts and was making efforts to be present on that day. It's not like he blew it off or anything, that he did make efforts to be there. So I'll find that the notice was insufficient. So then we move to the next issue, which is a motion to modify or rescind. At this point, the domestic violence protection order is set aside in that there wasn't proper notice given to Mr. Gall. So what we know at this point is that there's been law enforcement involvement. They've opted at this point not to bring any charges. There's been a CPS investigation with a founded finding that's being appealed, and that there's been polygraph. Polygraph is a polygraph, so we'll give it the weight that it's due. It's a piece to consider. So with that, with those findings, at least from CPS, I guess there's a call or a request to give deference to a CPS finding. I guess that there's maybe some rationale for that, and yet I think I would abdicate the responsibility given to me to make a decision if I would just say, okay, whatever they say goes. Certainly they're trained professionals. Certainly they have training and experience in making those types of findings. And I guess the court has some similar, if not different, experience in making findings. So the concern is the re-victimization of children, as kind of enunciated by Ms. Corey. And we know that Ms. Rosen has been the reunification counselor for a dozen or so counseling sessions. So what we know, there's concern also raised by Ms. Gall that Ms. Rosen is not, is forcing her will, basically, and it's saying it's not a child-led reunification process. That would come to me as a huge surprise, having worked with Ms. Rosen for a number of years. I would be exceptionally taken back if that was the case. My experience with her, and this may be different, she may have changed, I don't know. My experience with her is that she's not going to do anything that's contrary to the child's best interest. If reunification can occur and the child will be well and safe and protected, she'll move forward. If the child will not be well, safe, and protected, she's not going to move forward. She's not going to do that prematurely. That's been my experience. And I could be off on that. Things may have changed. She may have altered the way she does things. But history tends to be a good predictor of current and future behavior. So the Ms. Gall raises issues that the drive from the Tumwater, Lacey, Olympia area to Longview is long, takes a lot of time. She has to take work off, and that it's expensive. Gas doesn't come cheap. So at this point, the reunification counseling can continue under the supervision and guiding eye of Ms. Rosen to help offset some of the costs involved there. I will order Mr. Gall to pay for the gas money at the federal mileage rate to and from the reunification counseling to mother 24 hours in advance. If that payment is not received 24 hours in advance, then the counseling session will not occur. If it is, then it will occur. And at this point, the DV protection order is rescinded because there was improper notice. If there is a desire from Ms. Gall to have a hearing on that with full input from all the parties, that could certainly be noted up, and that can be heard and addressed, and have all parties have voice. So that's the court's ruling at this time.
And Your Honor, when we're talking about the DV hearing, we're talking about the restraining order in this case, not the domestic violence protection order that was entered a year ago. Is that correct?
Yes, I'm referring to the restraining order hearing that was set for the 24th of January of this year.
Okay, thank you, Your Honor.
That's the one that I'm saying there wasn't proper notice and should be rescinded, set aside.
Okay, thank you, Your Honor.
Okay.
Thank you, Your Honor.
Ms. Margraf, do you have any questions?
No, thank you, Your Honor. I appreciate your help today.
As far as a order related to the rescission or setting aside of that, Ms. Margraf, is that something that you could draft and forward to Ms. Winkles for her review and then forward it on to the court?
Yes, Your Honor.
Okay. I'll look forward to receiving that. And at this point, we'll be notified if there's other hearings related to the restraining order.
Will Your Honor weigh in on the Zoom calls and the supervised visitations as well?
I'm not sure what you mean.
And
Ms.
I
Margot?
would request that we have some discussion about Zoom calls and supervised visitation.
I'll defer to the reunification counsellor at this point.
Thank you, Your Honor.
Okay, so that'll all right. That'll conclude that matter. Then we'll move next to the Roberto Gull and Jesse Gull, cause 22381-08. There we have Ms. Winkles representing Ms. Jesse Gull. Ms. Winkles is present, and we have Mr. Gull on the line. And make sure all parties can hear me. Mr. Gull, can you hear me?
yes, I can hear you, Your Honor.
Very good. Thank you. Ms. Winkles, and you can hear me?
Yes, I can hear you. If I have your permission to turn off my video, I'm actually on a site visit for another matter, so I'm in my car.
Sure.
So I had an allergic reaction, so I would love to be able to turn it off just so nobody could see how swollen my face is.
I don't have any objection to that. I'm fine with that.
Thank you, Your Honor.
The record will also reflect that Ms. Jessie Gall is on the line with us this morning.
Your Honor, I was wondering, I arrived a few minutes late to today's session, and I was wondering if I could request an extension.
Tell me your basis of requesting a continuance.
Yes, Your Honor. It appears that many of these allegations have been addressed, and they've been addressed through prior attorneys. I've scheduled a meeting with a different attorney next week so that we can prepare a response properly.
Okay, and so we're talking about, there's kind of two motions, if you will. One's a motion for contempt based on an underlying order that was issued in August of 2022. There's issues related to passports, and there's an issue related to responses to requests for admission. And so let me ask you, Mr. Gall, you indicated that you're hoping to hire an attorney. Have you already met with an attorney and you have given them a retainer?
Yeah, we've had Your Honor, we've had an initial discussion, and I was made aware of a possible new discovery that would affect this case. And so even though I may not hire the attorney directly, he will help me prepare my response for this matter.
Okay. And then, okay. Thank you. Let me hear from Ms. Winkles, your position.
Yes, Your Honor. On the motion to deem matters admitted, really, I'm not trying to penalize Mr. Gall. I'm not trying to do anything of that sort. What I really want are the answers to that one. I mean, we're going to trial, and I just want to make sure that we're not in trial for 2 weeks.
Absolutely. Yeah, Your Honor, the answers are available.
So hold on, Mr. Gall. I'm going to let
Yes, sir.
Ms. Winkles finish without an interruption. Go ahead, Ms. Winkles.
With the motion for contempt and relief, I do want to go forward today because there's a couple of issues here. The first is just the fact that my client has been borrowing money for attorney fees, where it seems like Mr. Gall didn't do the same, and Mr. Gall used community funds for his attorney fees. And so that issue, I think, needs to go forward today. Trials are expensive. I'd rather not go through a trial, but there we are. Additionally, the passport issue. These are things that were ordered. Mr. Gall has had three former counsel, and the fact is these should have been addressed ages ago. We've repeatedly asked for these things to be addressed, and you can see in the emails. I think that one needs to go forward today, because otherwise we're just putting it off and costing my client more attorney fees, which really isn't fair to her. She's done exactly what the court's ordered. On the motion to deem admitted, again, really just looking for the answers. If his new counsel is going to help him prepare those, that's great. I know the court would likely not grant that anyway, just because, we give people a fair chance. We're not trying to, make it so that they lose out on giving their side of the story. But on the contempt and relief, absolutely, I think we need to go forward today, because that needs to be dealt with soon. We can't put it off for Mr. Gall to have a fourth attorney. He's had adequate notice of this. These were filed May 22nd. Here we are at the end of June. There's no response been filed, no request to my office for continuance. This is the first I've heard of it. The first I've heard of having another attorney. We were on a different docket yesterday. No mention was made of it then. So I'd ask that if we're going to set over the motion to deem matters admitted, no problem there. Set it over for a couple of weeks. But on the other issue for contempt and relief, I'd ask that we go forward today.
All right, thank you. All right, based on, so Mr. Gall has made a motion to, verbal or oral motion to continue today's motions to a separate date to allow him to have counsel. Ms. Winkle points out that the motion to deem matters admitted, that's a fairly big deal. That's where basically somebody's kind of like just checked out and is not participating. And, you know, while Ms. Winkles points out there's been quite a time lag for those answers to be responded to or provided, that there's a kind of underlying notion under the system we operate that we want people to get their stories told and have the information put out rather than just kind of defaulting and say, too bad you lose. So on the motion to deem the matters admitted, I'm fine continuing that matter. I think that will allow all parties, and I think that'll benefit everybody to get that done. The other two issues related to the contempt and attorney fees and the passport, there was a motion filed on May 22nd. We're about 3 weeks out from that time period. So notice has been given. There are some issues related to dollars related to the sale of a food vendor truck, which may be instrumental or helpful in determining where those funds are and the potential use of those funds, and also passports. That issue is outstanding. So I'm going to deny the request to continue on those two matters. I'm granting the request on the matters to
Your Honor, if I may ask.
Don't interrupt me when I'm speaking.
Okay,
Don't interrupt me when I'm speaking.
sure. How may I respond to the attorney's?
So I'll finish my comments and then I'll let you know when I'm done, but don't interrupt me. I'm pretty free in allowing people to speak their piece. And as you notice, when Ms. Winkles was speaking, I didn't want you to interrupt her there. And I don't want you to interrupt me when I'm speaking. It's just kind of a common courtesy.
I apologize, Your Honors. I was just, I'm not familiar with these proceedings, and I was just
It's not the proceedings issue. It's just kind of like you learn in kindergarten, you're not the basic skills. When a person is speaking, you allow them to finish speaking. You don't interrupt them. It's different for a judge in a way, because a judge has the necessity of kind of maybe cutting into people that are maybe getting sidetracked, and they have to redirect them. That's why the court sometimes will interrupt people, and it may seem rude and impolite. So as I was saying before I was interrupted by yourself, is that I'm granting the motion to continue on the motion to deem the matters admitted. I'm denying the motion to continue on the contempt and the passport issues. We'll hear that issue now. We'll hear from Ms. Winkles. Go ahead, Ms. Winkles.
Yes, Your Honor. The first one is that we were already here on the fact that Mr. Gall sold a food truck. We were able to secure contempt at that time. Judge Hahn made it very, very clear that Mr. Gall was to put 100% of the proceeds into the account. At the time, Mr. Gall stated that he had put it into a few separate accounts and had only put half in. We were told, Judge Hahn stated that he was to put 100% in, and I did supply those minutes from that hearing. That's Exhibit A. We made repeated requests to Mr. Anagnostou's office for an accounting of that trust. You'll see Exhibit B. We never received that. Mr. Anagnostou got out. Obviously, he doesn't have any duty to us to provide that now. We were assuming that they were all in there because we'd heard nothing about it, and we figured that Mr. Gall would listen to the court. It appears he didn't do so. At Exhibit C, it is an unofficial transcript of the hearing. It was a DVPO. Mr. Gall did state that he had taken out half and he had used it on attorney fees. The fact is that's not fair to the parties. This is a community asset, the food truck. It's then sold. Mr. Gall has bad faith and dirty hands because he takes it. And the contempt, the whole idea of that court order is that Mr. Gall was then to put it back in. Instead, he used it on his attorney fees, which I understand the fact that he needed money for attorney fees, whereas my client, who has, I believe, an $18 an hour job, has had to borrow significant funds, so much so that that the idea of her being able to go to trial with counsel is almost non-existent. I think, I'm trying to work with her on that. But the fact is she needs more than she needs to pay me. She needs to pay back the third parties that she's borrowed. So I'm not asking for another contempt because it clearly doesn't work. What I'm asking for is that Mr. Gall, or that, I'm sorry, that this court allow my client to have those funds that are in trust and have an order to Mr. Anagnostu's office directing those funds to be paid to my client in full. I believe there's $31,000 in that account. I'm also asking that he pay the judgment to my office for attorney fees. He's made 2 payments of $75 each. I was going to garnish Mr. Gall, but the fact is it would cost my client more to garnish Mr. Gall than it would be the $3,000. That would go a significant way to having a trial brief and all of those things done so that my client can have representation. Mr. Gall has a lot more education than my client has. They're in a definite different place of power. There is a DVPO entered. She just needs to have representation in this. She's not a sophisticated woman. She's a lovely woman, but she needs to have be afforded the same opportunity, which I'm trying to afford Mr. Gall as well, to have everybody be able to put on their case and have a judge decide this. So my client is asking that Mr. Gall, again, if should he be in contempt, that's fine. But really, we don't even need the contempt. We just ask Mr. Gall to pay what he's been ordered to pay, and not necessarily use it on a fourth attorney. If he has to, fine. But to have Mr. Gall actually pay what has already been court ordered to pay. Finally, we're also asking, there's been a court order for these passports, and that's been in existence a while. My client doesn't have money to take these passports and use them on the children. They're not going anywhere. Mr. Gall leaves the country. Mr. Gall was born in another country. Mr. Gall has made statements, according to my client's declaration, about taking the children. While he doesn't have any visitation right now, there's no reason for him to have passports. So what my client is asking for is, even if my client doesn't have the passports, that the passports I have, obviously as an attorney, as safe in my office, I'd be more than happy to keep those passports in the safe in my office until the trial. My client feels very uncomfortable with the fact that those passports weren't returned specifically. We've requested them and there's just no movement on that. So we're really asking for, again, I'm not asking to make Mr. Gall's life more difficult. I'm just asking for fairness and everything across the board, that those funds that are in Mr. Anagnostu's account be directed to be paid to my client. They can go through my trust account first. I can show an accounting and submit them to my client. Second, that Mr. Gall has a date certain where he has to pay the judgment. If not, that any attorney fees for garnishment of Mr. Gall's wages be added to that value, that liability. And finally, that Mr. Gall provide the passports to my office by no later than 2 weeks from today. And that if Your Honor wants to make an order stating that they remain in the safe in my office until trial, we have no problem with that whatsoever. Again, I'm not sure contempt really works. We've had contempts. They just don't seem to go anywhere. We're looking for action rather than a piece of paper at this point. Thank you.
Thank you. Mr. Gall?
Oh, yes, Your Honor. So, boy, that's a lot. So let's see. I'm going to start, first of all, so there are no contempts on record towards me on this matter. That's one of the many lies that this attorney is saying. Second of all, we've attempted to try to show an accounting for the funds that remained through my various attorneys. Now, this particular attorney has repeatedly shown that they are going to bombard my new attorneys and overload them with questions and informations, and they're going to deny and reject any submissions that I make. This is their goal, to try to besmirch me or make me look as an individual that doesn't respond. I have shown accounting at Judge Hahn's request. I have shown accounting to my previous attorneys, and my previous attorneys have provided that accounting to Ms. Wrinkles. Both Anagnostus, Bloom, and Margraf have provided this particular accounting. And this is the information that I have been looking to research to submit to the court, Your Honor, so that I can continue to provide proof that this particular attorney is utilizing abusive litigation to try to get her client's way through. Now, if the court would allow me, I am researching all of my efforts that have confirmed my intent to try to provide this money. I have no problem where this money sits. It could sit at Kurt Anagnostis' office. It could sit in Aaron's office. But until we all come to the table and try to resolve this matter, Your Honor, I mean, the respondent does have many assets which with value that can be opted towards this. And to respond to the respondent's attorney's claims of borrowing money, this money is not being borrowed. This money is being given by her mother, who is noted as a hateful, racist person who has been trying to break up her marriage for the last 10 years. So in addition to that, the respondent had claimed that she's paying rent and that she's working, but she's not, Your Honor. We are going to be submitting information that there are no financial obligations to this person, to the respondent, and that she's benefiting completely and personally from the child support that she's receiving from me, and that all of our attempts to try to resolve these matters through my previous attorneys are just their efforts to try to make me look as a bad person in this matter. If the court would allow me, I would definitely love to submit all of that information that'll prove this so that they can see all of the abusive litigation that's being done by this. In addition, another lie that this attorney has stated is that I've only made two $75 payments. While that is true that I made two $75 payments in check, I've also made a $300 payment to her office. Now, these payments are infrequent because I have other responsibilities, such as legal fees, medical fees, $2,200 mortgage, $1,100 in child support, which leaves me absolutely in the red every month. And this is part of their strategy. So in their attempt to try to increase my legal fees and try to run off my attorneys, they're trying to use the court system to try to paint me the bad individual in this matter. And all I'm trying to do is get rid of my previous relationship, Your Honor. The court is seeing that all of the abuse that I have sustained emotionally, financially, and physically from my wife and my kids who have sustained their emotional abuse and psychological abuse from her, is being translated into the court in this matter. The court, I'm not sure if this case knows that the respondent has been previously charged twice and convicted once of domestic violence, but she is not new to this process. But she has made very many accusations in which she said that the next time this happens, that she was going to do it right. And she didn't falter on her promise. She did everything she planned everything. And I wouldn't blame her. I mean, she's got an aunt who's been divorced 5 times in this exact same district. So they know how to manipulate the system really well. And I hate that they're using this court process to amplify that. Now, as far as the passports, that's another lie. My son's passport was issued when he was 1 year old, 1 year old. His passport expired and it's nowhere to be found here. I'm assuming that the respondent picked up this passport in one of the 2 times that she was granted access to come pick up her stuff. I do not have his passport. My daughter never had a passport issued. And to continue to perpetuate lies that I was going to take my children out of this country just so that they can continue to fearmonger both the reunification counselor and this court, it's just absurd, Your Honor. I'm here. I am a citizen of this country now, no thanks to my ex-wife, which she would like to claim. And I'm just trying to fight for my children. I have seen this court at this docket today be extremely thoughtful and mindful of parents' rights. Yet here I am sitting 7 months without seeing my kids after positive reports from all reunification counselors and all supervised visitations, just so that the respondent can try to manipulate reports to try to keep the children away from their father. Now, I understand the court doesn't really like to hear the word parental alienation, but it's happening, Your Honor. After all of the reports that I suspect may not have been turned into this docket, it is very doubtful that these matters are just happenstance. They are coordinated, and they are just an evil way to try to keep me from my children. I have no problem providing this same accounting that I provided to previous attorneys to communicate with the respondent's attorney and to the courthouse. I have no problem, and these accountings had costs, and not only in my attorney fees, but medical fees and housing costs that were relating to storm damages, which insurance rejected, which the respondent is also currently financially responsible for. And for this very reason, Judge Hahn allowed an accounting and communication between both parties. Yet here is the respondent's attorney claiming that I've done nothing, and all I'm trying to do is be able to respond and provide the truth.
Thank you, Mr. Gall. I have a question for Mr. Gall and Ms. Winkles. How much money is in Mr. Adeganostu's trust account?
$31,000, Your Honor.
Okay. And then the site follow-up question, and I'll give you a chance, Ms. Winkles, in a moment. And what's the basis of knowledge? How do you know that?
What is the basis of that knowledge?
Yes, sir.
I made that transfer to his account myself personally, Your Honor.
Okay. And so since that time of the transfer, have there been withdrawals from that that corpus of 31,000?
No, Your Honor. That was the remaining funds that I had transferred to Mr. Adeganostu, because I had requested that the court allow $20,000 of that to go back into the children's college savings accounts, which were used to purchase the house just a few months prior to the divorce.
So the truck sold for about 60,000?
The truck sold for probably 61,000 or 62,000, somewhere around there.
And was there any encumbrance against the food truck or any loans outstanding?
No, sir.
To be satisfied?
No, sir. The food truck had been previously paid off by a property that was solely in my possession, in my name, prior to my marriage to the respondent, and that the proceeds of that funds also went to pay the respondent's mother's personal loan. I think she lent out like $15,000. I paid her back $16,600, and those $16,600 were supposed to be paid back to me for my student loans when the truck was to sell as well. And so all of this is trying to be subverted or covered by all of these other wild accusations that I'm just trying to filter through.
So let me just ask you an additional question before I hear from Ms. Winkles. The order, it looks like from August 2nd of 2022, indicated that all food truck proceeds were to be deposited into Mr. Adeganostu's account by May 20th of 2022. And from what I've heard is that has not occurred, and only half of the funds, roughly 31,000, was deposited. So the other 29,000 or 30,000 was not deposited.
That's correct, Your Honor. They were never initially deposited. They had been reserved at the onset for the children. And in fact, Your Honor, they were transferred to the children's 529 account prior to all these court hearings. And as a result of the court hearings, they were transferred out. And that was part of my submitting documentation with my new counsel that I wanted to submit so that I can show you guys that I wasn't ignoring court orders. I was waiting for parties to take action, and I was waiting for agreements to be understood towards the accounting of these matters. And I was just waiting for a resolution on this matter. Now, to be completely honest, those funds have been used and my finances have shifted around. But if the court allows, I can have those funds available again as well. I mean, I have no problem asking for credit and making this done right. It's just that I wanted to make sure that the record was set straight and that the respondent's attorney's means and method of lies and their tactics, go with the proper response.
What's your response to this question? If it was okay for you to use $30,000 of that money, why isn't it okay for Ms. Gall to use $30,000 of those monies?
It is okay for Ms. Gall to use $30,000 of that money. Absolutely okay. Yeah.
So do you have any objection to an order that would transfer that $31,000 or $30,000 from Mr. Anagnostu's trust account to Ms. Winkle's account?
I do, Your Honor, because the proceeds of that food truck was solely in my name. That food truck's loans were paid off as a result of the proceeds from my property, not Jesse's property, that I had bought prior to my marriage and that I had sold, and that she had completely. So there are other parts of this story, Your Honor. So the respondent had promised to continue to operate the food truck, but she didn't. Instead, she used all of her mother's money to smoke marijuana and leave the food truck in shambles. So I had to come in and try to recover this business. So all I'm trying to do is just make the matter of the business complete. For example, I have proof that this food truck was paid with proceeds from my house, which I owned before my marriage to the respondent. And I have proof that I paid off a loan to the respondent's mother for loans that the respondent used to smoke marijuana instead of operating that food truck. So those are the issues that I wanted to bring up to the court in regards to that. And, I think that overall, at the end, everything washes out in the balance sheet. So, I don't understand that this respondent's attorney is refuting that we've made any effort to try to communicate with 3 other attorneys. All the while, I'm incurring all of these attorney fees. I've spent over $18,000 in medical fees just for this respondent to try to manipulate the system and keep the children away from me. Now I have to spend another $18,000 to reunify with my children that I haven't seen in more than 7.5 months. How is this fair, Your Honor?
Thank you for your responses, Mr. Dahl. Ms. Winkles, what's your response to my question of how much money is in Mr. Adekanostu's trust account, and how do you know that?
There is 31,000. The only way I know that is that Mr. Gall stated that there's 31,000. He stated it on the record repeatedly. It's in the court minutes. He also stated it in court today. Additionally, he stated in the DVPO that that's the amount that was in there. The food truck sold for $60,000. We provided proof of the actual document showing that the sale, I was given information on the sale. What I was not given information on was how much was in that account. And I never received that. And I'm assuming counsel for the last 3 know them well. They're decent counsel. They're not going to hold something back when I do discovery. Attorneys don't really have a dog in the fight in that way. Our ethics are very, very important to us. The fact is that there is 30,000 in that. I have no proof that this is from a separate asset. In fact, I have proof that the food truck was purchased through using funds borrowed from my client's mother through a variety of sources, and anyway, commingling all of that. The fact is that Mr. Gall has bad faith. There is intransigence here. There is a court order, and whether Mr. Gall liked that court order or not, that was the order of the court to put 100% of the food truck proceeds in the account, not to put it into his children's account, not to take it out, not to choose what Mr. Gall wanted to do, but to do what the court ordered him to do. And it is a hidden asset in the fact that while I have to go from what Mr. Gall says in court later on, the fact is that it's not been disclosed in discovery about how much was in that account. None of this has actually been disclosed other than by Mr. Gall today. Again, the whole thing about separate property, this has all been disclosed today. The fact is that it is a community fund. These parties have been married long enough to have, 2 children that are, one of them is almost a teenager. And this food truck is a community asset. He even said he bought it so that his wife would have a job. It was sold. He sold it contrary to court order. We brought him forward to the court. The court said you shouldn't have done that, but put all of the proceeds into Mr. Anagnostu's account. He didn't do that. The court gave him a date to do it. He ignored it. He took it out and put it into children's accounts. Apparently, I haven't seen that. I do have all of the accounts. I do see a lot of money moving back and forth, but then he spent it, and he's been honest with the court. I spent it. He's honest now. The fact is that honesty now doesn't fix honesty then. Honesty now doesn't make a court order complied with, and that's what we're dealing with here. The fact is that there's $31,000 in that account. He's had half. He's had half and spent it. The thing is that this is kind of kind of their marriage. What is fair for one is not fair for the other. And that's not what this court is. This court wants both of them to have an equal say when we get to trial. They both get the same say. Mr. Gall has spent that money on getting his say. My client has not. It's just number one, unfair. Number two, Mr. Gall should have some sort of liability for just failing to obey court orders. And this is one of those. It's clear that half of that money is in there. It's interesting that he took out half. I think that shows that he thought that she was entitled to that half anyway, because why not just take the whole thing, or why not take 10,000? He took half. There's a reason for that. He knows she's entitled to it. He put it in there, but the fact is that he would rather have spent it on his attorney fees than go about this by doing what the court ordered. He could have motioned the court at any time as well to ask for relief. Look, I took it, I spent it, I'm sorry. I don't know what to do here, but this is where we're at. He chose not to do that. On April 10th, that's when I found out that the money had never been put in. And that is when on May 22nd, I put this forward to the court. So, Your Honor, the position's the same. We can circle around, but the fact is there's a court order. He didn't comply with it. He spent the money instead. My client's entitled to equal representation, just like he was. My client's entitled to those funds. She has good faith here. She doesn't have dirty hands. She's asking for those funds to be transferred to my account and then to her. So I want that kind of clear. Is the funds go into my trust account. I would ask that the order state that I can then transfer them to her. She has so many debts to pay off because of this litigation. Mr. Gall used his to pay off the debts. My client should be using hers to pay off the debts, and not to me, but to her, the actual person that holds that debt. So I'd ask that those funds be essentially directed completely, 100% of the proceeds that are still in that account to my client. If they go through my trust account, fine, but eventually 100% to her to decide if she's going to, to obviously pay back the person that she does owe money to, and gives her a fighting chance at the trial.
Right, thank you. All right, let me just start with the passport issue. The indication, there's concerns raised by Ms. Gall that the passports could be utilized to take the children to a different country. And then Mr. Gall responds that the children, one child, I believe the son, had a passport issued at age 1, children's passport. It's my understanding are a lesser period of time before they expire. I think it's 5 years, whereas an adult, it might be 10 years. So his representation is that it's expired, and then that he denies that the other child has any passport ever being issued to that child. So I think my resolution on that is, if there are passports, whether expired or valid, that they be turned over by June 27th, or if there's not passports, then there need to be an affirmative statement by Mr. Gall under the penalty of perjury that he does not possess any passports. That includes either expired or existing. So if there's an expired one and then there's non-possession of that, then that needs to be stated under penalty of perjury. And if there's not a passport for the other child, then that needs to be stated under the penalty of perjury. Or on the alternative, if there are passports, whether expired or valid, those need to be turned over. Both those things, or one or either of those, needs to occur by June 27th. So that's the deadline there regarding the passports. Regarding the food truck sale proceeds, there was an order that all proceeds were to be placed in trust at Mr. Adagnostu's firm. The indication is that Mr. Gall did not do that. He put a portion, a half roughly, of those proceeds into the account, and there has not been a restocking, if you will, or a reimbursement of those other funds that are supposed to be there, which causes the concern to the court that there is a clear order of the court and expectation of the court, and it was not followed. So there's separately raised issues of potential separate property interests within those monies. There's issues of commingling and the like, combined with the concern for not following a clear directive of the court. So what I'm going to allow and require is that full $31,000 be transferred from Mr. Adagnostu's trust account to Ms. Winkle's trust account, and that Ms. Winkles would have authority to distribute $10,000 to the mother. The other remains frozen and non-accessible until court order. So the other $21,000 would remain in Ms. Winkles' trust account. So
Your
that's,
Honor,
yes, sir.
may I ask a question?
Go ahead.
One of the current issues right now is with the reunification counselor's fees. And because the respondent has actively and willfully tried to alienate the children from me, all of the progress that reunification has recorded up until November of last year, it's been 7 months now, has stopped. So would the court please allow $5,000 to be set aside for continued reunification from those funds?
It's a good question. I'm gonna hold off on that. If your new attorney wants to raise that issue could be raised. I would have clearly an accounting and the like of the funds, and I think the separate property issues need to be resolved. Prior to that, I recognize the reunification counseling does not come cheap and it's super expensive, and funds are in very short supply. I'm going to hold off on that and deny that request at this time. It could be certainly made at a future period of time if you want to raise that issue.
And Your Honor, finally, the 3,000, and if Mr. Gall has proof of the 300 in cash, I don't show that in my accounting. I'm willing to discount that and give it to Mr. Gall as if he did make it, even if he didn't. But the remainder of the funds, with what is it, 2,500, I believe. I went to law school because I can't add. So I'll let Your Honor add, but whatever 300 minus 75 from 3,000. I don't even need interest. I just ask that there be a date certain that he pay the whole amount so that my client can have a trial brief.
You know, Your Honor, I have a response to that actually, if I may.
Go ahead. Yeah, go ahead.
In one of the respondent's attorney's emails, she acknowledges that the respondent is responsible for auto insurance that she has not paid for 2 periods. She finally paid auto insurance this past period, but she still owes 2 periods of auto insurance and life insurance. This particular attorney, Ms. Wrinkles, had offered to offset her debt as a result of the respondent's lack of payment, which I have not asked the court to compel or to find in contempt. I've simply continued to ask for them to be responsible for their financial portions as well. Would Your Honor consider offsetting that as well?
And Your Honor, if I can quickly respond, the auto insurance, if I can get her portion and proof of the amount, I have no problem doing that as well and crediting my client with a little, to offset it, crediting my client with some free legal services in exchange for that period, because I did absolutely tell him that. And the 2 periods, the life insurance, there's no order on that. And I've never mentioned life insurance. I didn't even know there was life insurance. That's the first time hearing of it. The auto insurance, I have absolutely no problem if Mr. Gall can show me the 2 periods and her proportional share of that. No problem at all. Also offsetting that.
I have mentioned life insurance.
All right. So as far as from what I understand, that the attorney fees were ordered back on June 27th, 2022. The representation is that $450 has been paid in increments of $375 on 2 occasions. So that leaves a total of $2,550 outstanding. Then there's issues related to offsets, related to insurance, health and car insurance, or I believe that's what it was, some insurance payments. If the parties want to come to an agreement as to the amounts of those offsets, they're free to do so to impact that attorney fees. What I think is proper is that there be a monthly installment towards the payment, or the attorney fees, pardon me. And I'll set that at $75 per month. It needs to be on received by the first of each month, starting on July 1st, and then each month thereafter. I recognize that funds are in short supply, and that at least a monthly payment shows a good faith effort of making payment on that. So that'll be the court's order. And if the parties want to address the offset, they can do that privately and come to some type of agreement.
That works for me. Thank you, Your Honor.
Will Your Honor also weigh in on life insurance, please? Because that's been a dragging, it's thousands of dollars every year. And Judge Hahn forgot to mention it. but I'm hoping that it takes the same route as car insurance, Your Honor.
I'm happy to chime in on life insurance, but I know nothing about it. I'd have to have some type of a motion, something that prompts me to read and get up to speed on that. If the parties want to supply me with that, then bring a motion, you can do that. Or if that's something you want to just work out amongst yourselves, you're also free to do that. So I'll hold off on making any ruling on life insurance just simply because I don't know.
Appreciate that, Your Honor. And I do welcome communication from the respondent's attorney if she ever wants to communicate with me in an amicable way.
And I'm always happy to have communication by email. I'm out of the office a lot because of some of the other types of law I do. Emails always works well for me.
Understood.
All right. Thank you, Your Honor.
So let's just take just a moment to look at scheduling a presentation of an order from today's hearing. I would encourage the parties to look at June 27th at 9 a.m. for presentation.
And that works for me, Your Honor.
Mr.
That
Gall?
does not work for me, Your Honor. I'm actually traveling that day.
Okay. The following week is the 4th of July. So that we could look at the 11th of July at 9 a.m.
I'm available the 11th, Your Honor.
I'm in Your Honor's court already, so that's fine with me.
Okay. All right. So we'll go ahead and set the presentation for the order from today's hearing to July 11th, Tuesday at 9 a.m.
All right. Thank you, Your Honor.
Thank you, Your Honor.
Can we also talk about the reunification and the money that was supposed to be given to me before the drive? Could that also be given to Aaron? And he doesn't have a bank account to put that in because he's behind 2 payments for the unification travel.
Jesse, that's not before the court. We can talk. Go ahead and call the office and they can transfer that call to me.
Okay, sorry about that. Thank you.
Your Honor, if I may, I think there's a easy resolution towards this matter. If Your Honor remembers, you did order mileage at the federal expense reimbursement rate for reunification traveling. I am ready to pay that mileage at the request through our family wizard, and I am able to make those transfers as the court has made decisions. So if the respondent would activate her family wizard, those can be addressed without the court's intervention.
And the issue with that, Your Honor, is there's an active DVPO with no communication at all between them. I am willing to accept those payments at my office if Mr. Gall would like to bring them in, if that would be easier. But there is a no contact order between the 2 parties, and that's what makes our family wizard quite difficult. And my client would like to continue that no contact order and not alter it with communication between them. But I am willing to accept that payment at my office. It does need to be made 24 hours in advance. Even if Mr. Gall were to stick a check through the door, I would let Miss Gall know that it's there and that she can go ahead and go and I can apply it, put it into her trust account.
All right. So generally the court doesn't become involved in negotiations or settlements and the like. So the parties are free to work on the issues that have been raised. What I would encourage, email is a great tool and it's an inadequate tool at times. What I would encourage, it sounds like, the parties, scheduling is always difficult, but maybe Mr. Gall and Ms. Winkles, could communicate via email and to the extent you can, and then hopefully set an appointment, maybe even just for a voice communication to work out details, because there tends to be a nice ebb and flow with voice communication when people are speaking on the phone that is definitely lost in email. So it's not a court order, it's just a suggestion, encouragement if the parties could just set a time where Mr. Gall and Ms. Winkles could communicate, even 15 minutes and then work on an issue and then maybe set another time. So just an encouragement, you can take it or leave it, but.
I encourage that too.
He can contact my office today and set up a conference call. That works for me.
Okay.
So, Your Honor, I wanted to clarify one last thing that would say, the no contact order had no effect on the wizard. The wizard was there as a result of the previous case's command to be able to address children's needs, not just to communicate. I have no interest in communicating with my ex. So if this matter resolves, it results in driving the children and the court has allowed mileage, then that app is definitely there. It was used before during a non-contact order for the purpose of co-parenting children. This is no different, Your Honor.
Yeah, I'm not going to chime in on that, on the domestic violence protection order and family wizard. Those issues haven't been brought forward to me formally, so I'll hold off on addressing those issues.
All right.
We've got a presentation date set, and we've resolved the issues that have been raised today, and we'll as far as the motion to deem the matters admitted, I am continuing that. We'll continue it over to July 11th. And we can address the motion to deem matters admitted at that time. That will allow Mr. Gall to consult with the new attorney, and the new attorney can hopefully supply some response or to that motion and or the request. Mr. Gall.
All right.
Your Honor, so the matters admitted are not an issue with me. They've already been answered, and I'm ready to turn those in. It was the accounting that was an issue to me that I needed help in time for an attorney with.
Okay. All right. So we'll just set it for review on July 11th, that motion, and we'll hear it on that date.
Thank you, Your Honor.
All right.
Thank
That'll
you.
conclude today's hearing. Thank you. And I believe
Previous order related to passports and the like, that's been signed and it's already been filed. So now we're on to the motion brought by Ms. Winkle's client, Ms. Gall, related to a motion to have matters deemed admitted related to some 20 or so discovery questions that were posed to Mr. Gall. So I've reviewed the parties' pleadings that you've filed, and I have a nice timeline here of kind of where the case has been, and with Ms. Margraf entering into the case and then Ms. Margraf exiting the case, and kind of the timelines. So I'll hear from Ms. Winkles, and then we'll hear from Mr. Gall, please.
Yes, Your Honor. We originally served these about 7 months ago. I actually believe it's 7 months to the day. And RFAs are obviously 30 days. When we filed this case on May 22nd, they still hadn't been entered. We did receive some sort of response on Friday, July 7th at 4:46 p.m. Now, normally, it's not about the attorney fees. It's not about any of that. It's just about making sure that the trial is narrowed down enough so that we can get the issues. That's the purpose of RFAs. I am unable to do that. I have a couple of issues. I'm not sure if Your Honor has seen the responses. I believe Mr. Gall filed them.
Yeah, I have read the response. It's basically an email sent to Ms. Margraf.
Yes, and there's a number of issues. It's very clear on CR 36 request for admissions. It's very clear on how to answer these. The answer shall specifically deny the matter, set forth in detail the reasons why the party cannot truthfully answer or deny it. A denial shall fairly meet the substance of the requested admission, and when good faith requires that a party clarify an answer or deny only the part of the matter of which an admission is requested, the party shall specify so much of it as is true and qualify or deny the remainder. We don't have that here. Specifically, RFA 2, RFA 4, RFA 13, RFA 15, RFA 17, and RFA 20 are nowhere come close to meeting CR 36. In fact, the answers make it almost more difficult. They don't specifically answer or deny anything. Instead, what they do is they answer or deny some other question that wasn't asked. This makes it impossible for me to narrow the issues at court, but more than that, it makes it impossible for me to even know if they could have been narrowed. If we are coming to some sort of problem and there's a factual dispute, that's fine, that goes to a trial. But the way these are answered, I can't tell either way. I don't think anybody can. There's an objection which isn't allowed.
Ms. Winkles, let me just double check, because when I'm looking at the court record, it sounds like you're referencing specific, enumerated responses.
Yes.
From Mr. Gall. So what I have from Mr. Gall that I've reviewed is I have a declaration which is related to the passports, which has already been dealt with by an order. And then I have a 2-page declaration from Mr. Gall that indicates that I submitted answers to the respondent's request for admissions on February 20th to my attorney, and that's signed. And then there's a copy of an email that has a copy of a PDF kind of an icon, but I don't have anything else.
Okay.
Your Honor, if I may respond to that, or if I may weigh in on that.
Oh yeah, just tell me.
Sure.
where that's at and why I don't have it, because
Yes, absolutely, Your Honor.
Good.
Absolutely, Your Honor. I attempted to file these answers with the courthouse, but the courthouse had alerted me that these answers do not need to be filed with them and that they need to be presented directly to the attorney. Unfortunately, my work had me traveling for the last week and a half prior to my submission. And so I fell sick, and that was the reason for the delay. In my response, I submitted my efforts to try to answer these questions back in February, which is the declaration that I submitted, sir. But since I
let me interrupt you if I may, Mr. Gall.
Yes,
Could one or both parties forward to me via email a copy of the response?
I can do it right now, Your Honor.
Okay, whoever has it up and easy, that would be great. And Ms. Winkles, it looks like you're doing that. And so if you could send it to me and CC a copy to Mr. Gall, so he knows what's happening.
Absolutely.
And just so the court may know, Your Honor, I welcome any open discussions to an attempt to resolve these matters and answer them properly. I'm not trying to hide anything. It's just I don't have the money to hire representation at this point. And in my previous efforts to have an attorney, I thought that, that these answers were sufficient because I didn't hear back from my previous attorney. It is. So.
All right, thanks.
And those have been set.
All right, and the county has a beefy firewall, so let me just refresh here repeatedly and we'll see. Well, I was anticipating it would have been received by now, but who knows, sometimes with servers and the like and their time frames. I'm wondering if because the next matter up isn't necessarily a short matter, so I'm willing to indulge in about another 30 seconds of me refreshing the send and receive button in hopes that will somehow pull that email in, just like when you press the crosswalk button super fast, you think it's making a difference. So,
and Your Honor, that's fine if we wait. I'm due in the minor guardianship docket right now anyway, so I can always pop back in.
Okay. Well, it hasn't come in yet. So what I'd like to do, rather than just waiting, is to pause, and then I can address the Ritzer matter, and then we can come back to this and finish up with it. Related to the email that was sent to me, let me just pull that up because I haven't looked at it since.
And Your Honor, my legal assistant sent you one with just the RFAs in it because the other one had other documents. It had the declaration and things like that.
Okay. Yeah, I'm looking at that latter one now. So I see first request for admissions to petitioner. It looks like it's a 5-page document. And there are answers included in each of those. And then I remember earlier, Ms. Winkles, you had mentioned specific numbers where you felt that it was inadequate, I think, at some of the answers.
Yes, Your Honor. Number 2, RFA number 2.
Admit that you received $59,000 in payment for the food truck, and the answer there, please refer to questions answered in second set of interrogatories for an accounting of truck proceeds. Okay, and then the other concerns?
RFA number 4.
Admit that you cashed out a portion of your community retirement for the benefit of your own legal fees. Unfortunately, you and the respondent continue to drag this on with further false accusation and legal fees continue to accrue. Okay.
RFA 13.
13 reads, admit that you informed your son that you purchased a new puppy after the date of separation. Objection. This question violates respondent's freedom to live his life and communicate a new pet during authorized visitations. Okay.
RFA 14.
Which reads, admit that you have called both children names. The PG-13 rated names I've called the children don't compare the obscenities the respondent has called the petitioner in front of the children. Okay.
RFA 15.
Admit that you have an average yearly income of $75,000. That is incorrect. Okay.
RFA 17.
Admit that you spent time in the hospital due to drug intoxication. No, this is another lie perpetuated by the respondent.
And that one I'm on the fence about. It appears to be a denial. RFA 20.
20 reads, admit that Jesse Gall did not inform the police of the situation due to your immigration status. What immigration status? Question mark. This is another one of the respondent's racist remarks. I have been a legal resident for over 25 years, and contrary to the respondent's delusions, marriage to me has no bearing on my legal status. Okay. All right. So those are the concerns. So tell me again, Ms. Winkles. So it looks like on 17, number 17, that looks like that's a denial saying no, just disagree on that.
I think it is. That was the one I was on the fence about because obviously CR 36 says the answer shall specifically deny the matter. The denial shall fairly meet the substance of the requested admission. That one I was on the fence about. The other ones don't. They essentially are making statements that have nothing to do with the question. The first one.
What about 15, where it says admit that you have an average yearly income of $75,000? That is incorrect. In other words, no.
Okay.
I think that's a fair interpretation of that.
Okay.
And then 14, PG-13 isn't what PG-13 used to be. PG-13, F-bombs are flying all the time. There's really no holds on PG-13 movies anymore. So
is that an admit?
You see, that's the question. Yeah, it's not clear. It's not clear. So that one's a little unclear. And so then 13, as far as about the puppy, it kind of sounds like that's a yes, an admission. Mr. Gall, what do you think about that on 13? Is that an admission that you informed your son that you purchased a new puppy after the date of separation, notwithstanding freedom of speech concerns and be able to communicate with your child?
Your Honor, I'm not denying that I got a new puppy after my kids asked that the dog that stayed with me be returned to them. But I just don't follow the line of questioning. It seems very intrusive. And, based on my recent communication with the attorney today, I'm starting to see a pattern that really raises some concerns. I'm not denying it, Your Honor. I am admitting it, but I am asking, to what extent are they going to attempt to persuade the court in painting me in a different picture that I'm not? What's wrong with me obtaining a puppy?
Okay. So it looks like on 13, that a new, so basically it sounds like there's it's an
admission.
You're admitting to that. And then on number 4, that's the one talking about admit that you cashed out a portion of the community retirement for benefit of your own legal fees. And then Mr. Gall's indication was like, this thing's being dragged out and it's costing me a lot of money. So is that an admission or not an admission?
Well, so that was a very tough answer. And, since we took a break, the attorney and I have had a chance to reestablish dialogue, and that takes a little longer. Should I answer here or should I answer in writing, Your Honor?
I would prefer here, Your Honor.
I'm happy to do so, of course. During the sale of the food truck proceeds, I had attempted to return money back to the kids' education account. Apparently that didn't take place because the previous attorney was non-responsive to me. And that time, the respondent had taken the freedom to continue to accuse me of obscenities with my children. I sought help to protect myself, which required medical and legal fees. So I did have to use some of the funds that were earmarked for the kids' educational account for that, which came out of the truck proceeds. This was discussed last time, Your Honor, and not the community savings accounts. The community savings accounts, they were cashed out for me to get by, but not for anything else. There are some funds in there, but I mean, we're not even there yet. The respondent has not even provided me a first set of interrogatories. And when asked, all I met with is just pushback.
I provided those in 2022, just so the court's aware.
Let's just pause on that. Let's just stay focused on number 4. So number 4, admit that you cashed out a portion of the community retirement for benefit of legal fees. Is that a kind of just narrowing down?
It wasn't community retirement, Your Honor. It was educational accounts.
Okay, so that's a denial.
Yeah.
Okay. And then number 2 is the admit that you received $59,000 in payment for the food truck. Please refer to the earlier answers in second set of interrogatories for the accounting of the truck proceeds. So Ms. Winkles, as far as that, did you check on the second set of interrogatories, his response to that?
I did, and it's incredibly confusing. It doesn't state. All I want to know is if Mr. Gall received $59,000 in exchange for the food truck. It's a pretty simple question. The answer in the second set, it went on, it never gave a figure.
Okay, Mr. Gall.
Yes, Your Honor. So the answer to that specific question is a denial. The figure is incorrect.
Okay. All right. So let me just, I appreciate the collaboration. Thank you for forwarding, both of you forwarding the answers to me. I guess if my notes are accurate, the only one that we had a question about still, Ms. Winkles, is 14.
14, and then did we get 20? I didn't hear 20.
Let's go to 20, sorry. Admit that Jesse Gall did not inform the police of the situation due to your immigration status.
No.
Go ahead.
Yes, I guess the immigration status one wasn't clear either. It's just admit or deny.
I guess Mr. Gall indicates that he says, I have been a legal resident for over 25 years.
Just gonna check in with the party.
So I think that Mr. Gall, is that a denial
That's
that
correct.
Jesse Gall did not inform the police of the situation due to your immigration status?
Okay.
That is correct, Your Honor. Unfortunately, my ex-wife suffers from mental delusions of such matters.
Okay.
Mr. Gooday, I'll check in with you.
All right. And then 14, as far as calling children's names, is that a denial or admission? Whatever the names those were, whether they were G,
Yeah, yeah, if I may get a little graphic, Your Honor. Yeah, I did call him, less offensive words, no F words or F bombs or anything to that sort, in a few moments of anger. So I'm not denying that. It's very focused, and but that's okay. I did, in a moment of anger, blur out a bad name to my children. No F bombs to that effect, though.
Okay. All right. So that sounds like that's an admit with a little explanation.
Yeah.
Okay. So
I appreciate this, Your Honor. Thank you.
Yeah, I'm glad we can kind of sort things out a little bit. So, Ms. Winkles, as far as like the information that you've received today from Mr. Gall, does your motion entail any additional requests?
Yes, Your Honor. I asked for attorney fees again. My client makes essentially a little over minimum wage. I sent these out 7 months ago. I filed this action May 22nd. I only received these answers on July 7th at 4:46 p.m. In the last hearing, Mr. Gall said he'd have an attorney and he was talking to somebody, he'd get them to us. We literally got them 14 minutes before closing on Friday. It's now Tuesday. I've had to be here a number of times. I continued it because I just wanted the answers. Had he just mailed this out 7 months ago, or 6 months ago when they were originally due, there would be no issue. Had he mailed them out May 22nd, I could have struck this whole thing. I've been here twice on this docket at a significant cost to my client, and I'd ask for attorney fees in the sum of $1,500 or whatever Your Honor deems appropriate.
The initial filing, you said it was in January? Or
January 11th. It was 7 months to the day when we served Mr. Gall's attorney.
Okay, thanks.
Your Honor, may I respond?
Please.
So, Your Honor, as you can tell by the last declaration I submitted to the court, I attempted to provide these answers in a timely manner. Not exactly sure why my attorney did not reciprocate with an elaboration or a discussion of those, or why they were not turned in. So here I am trying to catch up with all of this attorney's efforts to try to bombard new attorneys with information in an effort to drown them and have them fail in their representation of me. And additionally, Your Honor, I find this request very hypocritical, since I have in writing from this attorney that she will not be charging her client today, as she's on the docket for other matters. I'm sorry, I was speaking, if I may.
Go ahead.
So, I find myself very, very disturbed trying to figure out an amicable way in which we can discuss and get these answers. But instead, in which I can provide all of this information to the court, I just, I met with petty resistance from this attorney via email in my request to try to move things forward. I'm not denying the fact that this is a timely process for everyone, but I certainly do welcome the possibility of email agreements as the court has requested in the past. And finally, if I may remind the court, this hearing today was set for a presentation for which an agreement has already been signed. So if the court would please consider my efforts and my lack of income, and I'm just at my financial wit's ends to this, I really would like to bring some matters to the court that will exemplify how this one-sided attack is not being seen by the court, and by which I've let go other matters in which the respondent has been in contempt of court with matters of health insurance, car insurance, and so on and so forth. So please, if the court would consider waiving those attorney fees, that would be very beneficial in attempting for me to get back together with my life and my children.
Thank you. Ms. Winkles, just brief reply.
Yes, Your Honor. When I emailed Mr. Gall, I said I wasn't charging my client for the massive bombardment of emails today, because clearly she doesn't have the money, and I was already on a different court hearing, which I was charging for. I'm charging for anytime I talk, that's when in court, that's when I charge. The fact is that the discovery he's talking about was sent to Mr. Anagnostou back in my answers back in 2022, July 18th. It was 860 pages. What I told Mr. Gall was I couldn't email it because it was too large and my servers wouldn't allow it to go through, and that I could not, in all good faith, charge his missus in this case $86 plus $50 for the legal assistant to do that, because she'd already been charged for it one time.
I said I didn't know if I was even able to charge Mr. Gall that and that we should bring it to your honor because I've never charged an adverse party for any documents. That is what I said to Mr. Gall. I'm happy to give him that. I'm not trying to hide it. I already served it on Mr. Anagnostou back in 2022. He's welcome to pick it up. I can put it on a flash drive. Normally I would charge for that, but just to be done with it, I don't mind doing that. I just don't want to charge my client anymore. Frankly, she just doesn't have the funds for it. Regarding the insurance and all those things, we were already here on June 13th and he made the same comments that he was going to present all this evidence to the court and he's going to show them what's really going on. And here we are, July 11th, nothing's been put forward to the court. I'm not sure what to do at this point other than just try to we've set it for trial. I'm just trying to move forward, get all the discovery done and move forward and have this be ended so that we're not here forevermore. The fact is Mr. Gall makes a lot of money, makes $75,000. My client makes barely over minimum wage. She lives in a house rented out at a discounted rate because I believe one of her family members has it. Neither child sees Mr. Gall due to Charlotte Rosen's recommendations. My client fled a domestic violence situation. He lives in the marital house. My client has received no spousal maintenance, minimal child support, and frankly, she can't afford what's being asked of her. He took $30,000 out of a community fund and spent it on legal fees. My client didn't do that. We have an order to Mr. Anagnostou. We're waiting on the amount the court's allowed for that. We haven't received it. I've discounted my bill as much as humanly possible for the size of case that this is. But frankly, she just doesn't have the money. And unfortunately, I'm a solo practitioner. I can't just make it free, even though I'd love to do that. So I'd ask for $1,500. He can continue to make payments. I'm okay with that. He has made a good faith payment to me recently. But frankly, she just, or we can take it out of the community funds at the end of the trial. But she just doesn't have the funds to keep coming back. This is no fault of hers. If Mr. Gall tried to fix it with his attorney, his issue is with that attorney, and he should take it up with that attorney rather than having my client pay for something that should have happened and didn't happen.
Okay, thanks. So the issue we're talking about is the request for attorney fees. So it looks like the requests were sent in on January 11th. It looks like Mr. Gall responded to his attorney, then attorney at the time, Ms. Margraf, on February 20th with the responses. I see Ms. Margraf withdrew on or about first week of April. Thereafter, the motion was brought on May 22nd. And thereafter, we had a hearing on that motion on June 13th, and then the responses were given on July 7th. There's a little bit of fine tuning here today based on those answers, not uncommon, given that Mr. Gall's not a lawyer. So the amount of time that's flowed from January till now is about 6 months. Mr. Gall responded in about 5 weeks to his attorney after he was initially served. And then it was about 5 weeks from the hearing until he submitted his response on the 7th. So, you know, there's some delays there. I can understand that somebody who's supplied information to an attorney would have a solid understanding that attorney is going to do what they need to do with that and supply it to the other attorney. Then that was brought to his attention on May 22nd on or about when the motion was filed. And then thereafter, about 2 weeks or 3 weeks transpired until we actually had the hearing. And then I'm making an assumption that Mr. Gall probably talked to maybe a legal counsel or others related to how to kind of respond, and got it in on the 7th. So I think there's a fairly good effort on both parties' parts, but it took some effort to get us here. And that effort generally means time and money for both. So I'm going to impose $350 of attorney fees, less than the requested $1,500. And I think with the presentation, it's not going to be a lengthy order by any means, but we could look at 1 or 2 weeks, either the 18th or 25th, if the parties come to an agreement of what the court ordered here today. Basically, it's attorney fees, and that Mr. Gall has supplied answers to the to the admissions requests.
I am available the 25th, Your Honor.
Yeah, the 25th works for me. My son has a camp in Portland that I have to drive to next week, so that'd be great.
25th of July at 9 a.m. If the parties agree. Simply make sure that signed order gets to me by both parties, and then I can sign off on it, and then we can just strike the hearing. Mr. Gall, question?
Yes, Your Honor. The agreement had previously been signed, but having noticed some of the respondents' attorney's tactics, there's some verbiage on the request for the money to be removed. The court never specified that I needed to initiate the request to my previous attorney. And so I was wondering if the petitioner's attorney could make the request directly once the order has been confirmed.
I'm confused, Your Honor, what's being requested.
Yeah, could you explain that to me again?
Yes, Your Honor. So it was my impression that today was going to be a presentation, and that the facts that I had previously signed 2 weeks ago were going to be submitted and finalized.
It is.
But in doing so, I saw a note on, it said that the attorney, I'm sorry, the petitioner's attorney added that I needed to be the one to make the request to transfer trust accounts, and that was not specified by the court. And I was wondering if that could just be edited out, since we have presentation in 2 weeks, that Ms. Winkles can make that request herself to Mr. Anagnostiu once the court has approved that.
So I guess my question then, Mr. Gall, because I'm looking at the June 26th order, which related to the passports and also the trust account monies. It looks like it was signed by Ms. Winkles and it was signed by Mr. Gall.
That's
So
correct.
what that tells me, when both parties sign off on it, both parties are comfortable with the language that's been signed off on. And so when I see that, I just look at, make sure it looks like that's what I ordered and I sign off on it. So to go back to change that, I think would require a specific motion, because I kind of take people at their word that if they signed off on it, that they said it's fine. And now you're telling me that it's not fine, you want to change it. So if you want to change that, then you'd have to file a motion to amend that order.
Okay, Your Honor. I appreciate that educational step, and it's not something that I just changed my mind on. It's a pattern that I recognize today. So I appreciate that, Your Honor. Thank you.
Okay, and you know, the issue is, you know, that's, you know, it says, indicates here, it says where is it?
I can write the letter, I think, if Your Honor doesn't have a problem with that, and just hand it to Mr. Gall if he doesn't want to have contact with Mr. Anagnostiu. It's just because it's a trust account. It's technically in his name, so it has to be, I can give the court order, but also that's his client and the trust is in his name. So I thought kill two birds with one stone, get a court order and a letter saying, please transfer this.
Got it. I appreciate that, Aaron. Thank you so much. And it's just, I'm trying to avoid legal fees. That's all.
Sure. Yeah, I think the order, you know, number 4, it indicates Mr. Anagnostiu shall, at the behest of Mr. Gall, transfer the entire trust amount to Ms. Winkles' trust account. So generally, you know, if Ms. Winkles were to say, Mr. Anagnostiu, you need to do this, Mr. Anagnostiu may say, I need to hear from my client or former client. And so if there's a letter that's signed by Mr. Gall that's prepared by Ms. Winkles, hopefully that'll do the trick and get the monies over.
Okay,
Understood.
I'll do that.
Okay, very good.
Thank you, Your Honor.
That'll conclude. All right, can we next go to the Roberto Gall and Jesse Gall matter, which is cause 22381-08. There, let me just double check, see if the parties are present.
I'm here, Your Honor. Aaron Winkles appearing on behalf of Jesse Gall. I'm having trouble getting my video started for whatever reason.
Oh, okay. All right, that's fine. And then Mr. Gall, I see that he's present. Mr. Gall,
I'm here, Your Honor.
okay, great. Very good. So we're on today for just presentation of a summary of an order that was given previously, and it's related to the motion to deem matters admitted. Ms. Winkles prepared a proposed order related to that hearing, and then Mr. Gall, did you receive a copy of that proposed order?
I believe I did. I received a file copy from her office, Your Honor.
Okay. Do you have any concerns with that proposed order?
I think it was everything that we spoke about the last time we were present.
Okay. And then I just wanted to double check with the parties. Looking at where it says on line 23, it says the respondent's first request for admissions to petitioners, and then it enumerates 13, 14, and 20 are deemed admitted. When I was looking at the clerk's minutes, and the parties can refresh my memory as to this, indicated that 13 and 14 were admitted, but 20 was denied. And I just wanted to make sure that everybody felt comfortable with 13, 14, and 20 being deemed admitted.
Give me a second, Your Honor. I appreciate that being brought up to my attention.
And those were in my notes as well, that it was 13, 14, and 20.
Give Mr. Gall just a moment to look at that.
Your Honor, that's correct. Number 20 was denied. It was a false accusation again. Thank you for bringing that up to my attention.
So when I was looking at the clerk's minutes from the hearing on July 11th, it indicated, so Ms. Winkles addresses court regarding inadequate responses on 2, 4, 13, 14, 15, 17, and 20. Court and Mr. Gall address questions and responses that were unclear. Mr. Gall responds the following: 17 denied, 15 denied, 13 admitted, 4 denied, 2 denied, 20 denied, 14 admitted. So that's where the ambiguity comes from.
Your Honor is correct. 13 and 14 were admitted and 20 was denied.
And I have 20 as admitted, but it's admitted as in he answered the question. I don't mind. It just means another issue for trial, which I'm not concerned with because there were only 2 other ones admitted. So it's not a problem with me. We can cross that number 20 off.
Okay, so I'll strike I'll strike and 20 and just leave it, everything else as is. Any other concerns related to that proposed order, Mr. Gall?
There are no concerns, Your Honor. Thank you.
Okay, with that one omission or striking, I've signed off on that order.
Thank you, Your Honor.
All right, that'll complete things for today. Thank you.
And it looks to me like, sorry, very slow computer today. Looks to me like we are on for readiness the 31st of this month and trial the week of November 6th. Mr. Gall, you are the petitioner. Do you have any issues, concerns, things that need to be addressed today?
Yes, Your Honor. Good morning. Frankly, I'm surprised that this is happening. I was notified by the guardian ad litem at 11:30 this morning that there's a pretrial. That's the first I've ever heard about this, Your Honor. The last time that this attorney served me was 2 weeks ago with interrogatory paperwork that was requested a year and a half ago. So I'm a little shocked to be here. I had to rearrange my schedule, and I still don't know the rest of this trial information because I was not properly served. I'm happy to comply and get through this process. I just need to know what the rest of the dates are and when I can submit my talking points or my arguments.
And Your Honor, just a brief reply. It's not the attorney's office that serves Mr. Gall with the readiness hearing or any of these hearings to prepare. That would be the court emails it to both of us, as long as the email's on file, and it's up to us to make sure our emails are correct. It has nothing to do with me. I served him. We set the original trial date the week of, and we set these dates. I'd asked to go forward. We're both ready. We all have discovery. It's just a matter of time now to get the trial briefs in and our witness list.
Your Honor, may I respond?
Yes.
I appreciate that explanation, Ms. Winkles. I do not feel that I am ready. I had a second set of interrogatories that hasn't been returned to me yet. I just received your first set 2 weeks ago by your process server.
I have not received any second set of interrogatories from you. I've received a request for admissions, which were answered. I received interrogatories and requests for production, which were also answered. This case has been going on quite a long time. I believe it's we're hitting on 2 years now. We've had plenty of time to do discovery. The fact that Mr. Gall waited until after we've scheduled the trial is concerning. If he would get me that, I will. The November is the trial. It's the week of November 6th, if I'm correct.
November 6th.
If he can get me that discovery request by the end of today in my email, I'll have it to him well before that. I will try to get it in by Friday because this trial needs to go.
Okay. Lastly, Your Honor, I do have email documentation from my previous attorney stating that this matter was going to be sent to a negotiation rather than a trial. And that was the last time I heard from Ms. Winkle's office in reference to settling this matter. I'm happy to provide that as documentation and as additional support that there's been no communication from this office to me so that we can try to reach a settlement or an agreement or complete this process.
And Your Honor, just respond. My client, alleges that she's the victim of BV. We had the MSC waived. My client does not want to settle. My client would like to be in a Zoom courtroom with a judge making the final determination.
So, Mr. Gall, it does appear that your previous attorney signed off on an order waiving mandatory mediation back on March 28th of 2023. So
waiving it?
That is correct.
Oh, okay. That's great to know.
Your attorney was Miss Margraf.
On Margraf was my last attorney. Yeah, unfortunately, she was too expensive for me, and my finances are running low. That's actually another question that I have for you, Your Honor, if I may. Um, I I know that I am pro se. I know that it's probably not advice, but unfortunately, my wallet doesn't allow it. Previously, during this matter, the court had decided that I be responsible for $1,100 of child support monthly. The state has been very proactive in maintaining that order. And I have been fighting my finances and all of mother's financial attacks through her attorney to try to stay afloat. I feel that the $500 that are left in my account every month isn't enough to cover for bills, food, or any additional expenses. I would like to submit all of that documentation for trial. Would that be appropriate, Your Honor?
So the first thing is I can't give legal advice. However, I will say anything that you want the judge to consider as part of your case for trial should be submitted by way of an exhibit at the time of trial. There are some rules and there's some insight provided on the Superior Court, Cowles County Superior Court webpage for if this is a Zoom trial, how you have to go about doing that. So there's some guidelines there that may be able to help. There's additionally services offered on Monday from noon to 2 on the second floor of the Hall of Justice. There's legal aid attorneys at volunteer time that you can ask, come into the courthouse, talk to about how exactly you would get that stuff together to present to the court. You can also reach out to Northwest Justice, which is a statewide low-income agency that works with people to do some of these things and sometimes can provide, just instead of actually representing you in a case, they can provide insight and information on how to do some of these things. So I would encourage you to reach out to those folks. But yes, there's a way that you can absolutely do that, and the court would be able to then take that into consideration.
Great. Thank you, Your Honor, for that. Two more questions about pretrial and readiness, and I think I may be done.
Sure.
The next question is, can I subpoena people to testify during trial?
Yes.
Perfect. Okay. Subpoenas, good. And the last question is, custody. Actually, I think there's two more questions, but let me deal with custody. If custody is still being reviewed by the reunification counselor as ordered by the previous judge, I forget his name, would custody then continue to be an ongoing concern because it won't be, the reunification counselor does not have enough data by the date of trial?
That's a great question. I can't really answer that for you. Ideally, at trial, all matters would be resolved at that point in time. If there's a situation where there is reunification or some other ongoing counseling treatment services to any of the parties, the court would obviously need to know that, be aware of the timeframes around that, and it may impact the ultimate decision. So I can't really give you a solid answer on that, but that's definitely, I'm assuming both parties, that's something that they would want the court to consider.
Yeah, absolutely, Your Honor. So currently reunification has been delayed by mother for many reasons. And custody is definitely not set. It's not ready. Okay, and then the last question that just popped in my head is the home. That home needs to transfer so it can be uploaded and be out of this picture. That is also handled at trial, correct?
Correct. Trial would hopefully, as I stated, resolve any financial issues, property issues, child custody issues. All of that would ideally be resolved through trial.
Okay, and if a reunification counselor comes and says that she needs more time, would that impact trial at this point or trial dates?
It may. It's hard to answer that question again.
I would like to get that information across to the court and in front of you, Your Honor. I will be submitting that for reconsideration of trial dates, and that will be submitted today or tomorrow.
Okay, we have, I am gonna pass this case to readiness, so if there are those type of issues, you can raise those at readiness. Currently, that is set for October 31st at 11:30 a.m. That is a Zoom hearing just like this, and it's the Universal Readiness Docket, is what it's called.
Yes, okay. So as long as I file all of my exhibits by this date, I should be ready?
That is the hope, yes.
Okay, perfect.
And I failed to ask Ms. Looney, any concerns as far as the state's concerned, or is the 31st and this week of the 6th still work for the state?
Those days still work for the state, Your Honor.
Perfect.
And Your Honor, is trial only on the 6th?
It's set for the week of the 6th. It looks like there's a request for it to be more than one day. So on the readiness docket, the week before is when you get the specific days of the following week that you'll be in trial.
Got it. And readiness docket is when the information by the reunification counselor will be assessed by the court to see if trial will continue?
If there is a concern there, that can be raised at that point in time. Yes, sir.
Okay. Thank you so much, Your Honor.
All right. Thank you. And we will pass this case on for readiness.
Your Honor, Gall versus Gall, I'm requesting a continuance as well. I wasn't given a chance by opposing counsel to respond.
Aaron
Okay.
Winkles appearing on behalf of Jesse Gall.
All right. Go ahead, Mr. Gall.
Yes, sir. I'm sorry. Yes, ma'am. I was served on the 20th of December when the other party knew I was out of town. Obviously, this is perfectly timed for their portion, but I just haven't had a chance to respond and give the court my side of the story so that the court can make a proper decision, Your Honor. And all I need is until the first week of January so that attorney can continue with her request.
So you're asking for 1 week to next Tuesday?
Yes, that's correct, Your Honor.
Ms. Winkles?
You know what? If it's only 1 week, I'm absolutely fine with that.
Thank you, counsel.
All right. So, and this is my last docket of this matter, of this nature, I guess, on any reoccurring basis. I'm just going to give a heads up to the parties about a GAL, and I don't know if a GAL is something that's been considered, but it's interesting that there isn't one.
There was one. It was she was appointed in the protection order because that's where this case, which was originally signed, was the parenting plan was even under the protection order. Yeah. Okay.
Perfect. I just didn't see it under here. All right. So we will set the matter of Gall and Gall, which is 223-000-8108 over 1 week to January 2nd at 1:00 p.m.
And Your Honor, I can still file by the end of tomorrow, correct? Before for the court to have by the 2nd?
You should be able to do that, yes. And what I would encourage, if you are concerned that the judge won't have, that it won't get into our computer system, you can always file an extra bench copy and have that directed to the judge for review.
An extra bench copy. Thank you, Your Honor. Appreciate
No problem. So January 2nd at 1 p.m.
Thank you.
Sure.
And I have Gall and Gall 223-81-08.
That matter's ready, Your Honor.
All right. And did you receive Mr. Gall's response?
I did, Your Honor.
Okay. So
was that response timely to the court, Your Honor?
I think there was a note from the last hearing that it probably would have been late, but it was obviously set over to allow you to file that. So I'm assuming that that's.
Yes, I just wanted to make sure that the court did receive it. I believe.
I did receive it.
You did. Thank you so much, Your Honor.
I did receive it, and it's in the court file. It's document number 186.
I appreciate allowing me to submit my response.
So, I'm a little confused. And again, I'm coming into this case obviously a bit late into the game. It looks like you're asking to withdraw from the case, which the timing on that, I think, comes up pretty quick as far as your standard withdrawal, if I'm not mistaken. Is that right?
Yes, Your Honor. So actually asking for three different things. And first, so my withdrawal has nothing to do with my client whatsoever. It has to do with a disagreement about how it should move forward and interactions with Mr. Gall. Essentially, what my client is asking and what I'm asking as well on behalf of my client is not only to allow me to withdraw, but to continue the trial. There are two trials set currently. We've already been bumped once. There's one that's in civil priority week. I believe it's in June. That was already June or July. That was already set by the court. Another one, which was coming up at the end of this month, and that was not in civil priority week. Obviously, if my client was to retain new counsel, she would need it pushed to the second one. My issue here, and I've already spoken with my client and gotten consent, is that the child, Caleb Gall, needs to have an attorney appointed. It is essential in this case for this child who has a voice, who wants to use the voice. I am morally opposed to putting children on the stand. I won't do it. I don't, no matter what. I have an 8-year-old myself. I don't believe in it. This is where the disagreement lies. However, I do understand. I believe it is vital in this case. That's why I'm asking for a withdrawal. It has nothing to do with my client. It has everything to do with this little boy. That's where I'm at in there's this fundamental disagreement over how the case should go forward. Additionally, as I've stated in other hearings, I do fear any retribution at the end of this from the petitioner in this case. It is a concern of mine. It's been on the record before. There's a DVPO in this case. So kind of just to give a little bit of background, this case originally started as a domestic violence protection order. My client was granted that. It was re-upped. That was granted as well. My client fled with her children to Squamish, I believe, or I can never pronounce it. And Mr. Gall has had no in-person contact with the children for a considerable amount of time. There are counseling records on file. The children are in reunification counseling, believe they only have video visits. My client would object to any hearsay statements. I don't see any declarations signed in their affidavit or penalty of perjury from any of these people. Essentially, what you have is a declaration of Mr. Gall stating what he believes they would state. My client would state that that's not what would be said, or we'd have it before the court. We've got counseling records. We've got CPS records. We have police records. We have all of that. It is concerning that Mr. Gall still takes no stock in his actions being an issue here. Once again, this is made about me. Once again, I am the bad guy here as the attorney. The laser focus on me is one of the reasons I'm asking to withdraw from this case. I feel that it's not only muddying the issues, but it is personally concerning to me, given the history in this case. Mr. Gall has now asked for reunification fees to be paid out of, there's about a $20,000 amount that's held in my trust. That comes from Mr. Gall, in contempt of court, sold a food truck for $60,000. Judge Hahn ordered him to put the entire amount into his trust account with Kurt Enignos, his first attorney. He's had 3. And Mr. Gall did not do that. He spent $30,000 of it. He put the rest in. Judge Evans gave my client $10,000 for legal fees of the remaining 30. There's now whatever this 20-something amount in my trust account. My client is asking for 10 of that. Mr. Gall has already spent 30 of it. She's asking for that 10 in order to find a new attorney. Mr. Gall was ordered to pay reunification costs. He has not done so. So now he's asking for the additional 10 to pay for his reunification costs. This appears a bit disingenuous, considering it appears Mr. Gall was on vacation for the entirety of the last month. My client believes if he was on vacation, able to pay for that, why isn't he paying for his reunification fees? I don't believe child support has been paid this month. He's not paying much else. No spousal maintenance or anything of that nature. My client has essentially a minimum wage job. That's kind of where we stand today. Mr. Gall is highly educated. My client is not. There's definitely an issue here. Additionally, my client, being a victim of domestic violence, has significant issues putting together anything. And my concern is, if I am allowed to withdraw, and I do need to withdraw for personal reasons, if I am allowed to withdraw, my client, there is no way that my client will have the ability to present anything to this court, nor will she be able to be cross-examined by Mr. Gall. I believe it would be incredibly detrimental to her mental health, and it would just be a complete, there would be an inequality of power, and it would not serve the interest of justice. So essentially what we're asking for is that I be allowed to withdraw, but prior to that, that Mrs. Gall be allowed to use $10,000 of the remaining funds in trust to hire another attorney to take this to trial. There's already been some ER 904s and some things like that, back and forth. That Caleb Gall be appointed court-appointed counsel. He is of the age where he has requested it. I'm making that request on his behalf. It appears from Mr. Gall's documentation that he has no issues with that, and that finally that the trial be moved to that secondary trial date, which is already on the calendar, which there's no need to go to a special trial set, and that the parties resolve it that way.
The child is 10 or 11?
I believe the child is 11 years old.
Has there been a guardian in this case?
This is where it gets really strange. This was handled originally under Commissioner Nelson in the protection order docket, including the family law. So there was a guardian ad litem appointed. I believe it was Ms. Corey, actually, who's here, was appointed in the protection order. And she was on that case for a significant amount of time. She did put in a final order into that case, and I believe we did file it in this case as well.
Your Honor, may I reply?
Sure, go ahead.
Okay. So, Your Honor, I believe that this isn't the first time that an attorney has taken their last effort to try to martyr themselves in an effort to disengage with a client that they no longer agree with. As was made evident in my submissions for pretrial, I have presented to the court information, indisputable information that confirms that the respondent had lied to this court and misled them, all in addition, all with the assistance of Ms. Winkles, who obviously has a financial interest in this matter. I have no reason to deny Ms. Winkles departing the case. It's just the timing. While Ms. Winkles will continue to attack me and pretend that I am a bad person just so that she can try to get her way and not be responsible for the lies that have been documented to this courthouse, for which she will be responsible for at some point, then I want to make sure that the court understands why the comments have been made. In Ms. Rosen's report from a year ago, and again, as of a few months back, there's contradictory information. These reports have been submitted to the court, and the only difference that has happened in that time is that Ms. Winkles has successfully manipulated the court to prevent me from seeing the children. Part of my evidence was to show the drastic change in the report. That one report showed progressive and exponential progress between the children and I, and that the last report showed a lot of regression from the children only while being exposed to the mother. Now, I have told this court that mother suffers from mental issues. Obviously, Ms. Winkles has just confirmed that. Now, these issues are starting to affect my children. My son has reported to the reunification counselor suicidal thoughts. My son has reported to me that he is so overweight that his health is of concern now, and he has to wear a heart monitor at the age of 12 years old, that he can't take 2 or 3 steps. This coincides with the way that my ex-wife manipulates the children. She feeds them junk food and lets them do whatever they want, even play violent and sexually aggressive games such as Grand Theft Auto. all while she's claiming that I am the bad person. And Your Honor, I was definitely looking forward to a trial on January 22nd, because this trial was definitely going to allow me to show everything that I held back on. I was going to bring witnesses such as police members. I was going to provide every report provided in which none of these allegations continue to support their false accusations. But now my children are suffering. They have tried to punish me financially. They've said that I have gone against court orders, but all I did was sell property, and I did take a punishment for it. I paid fees in return for that. This is a last final run for these trust funds. If the court has had the ability to submit my pre-trial documents, the court will know that there is an excess of $160,000 in negative equity, something with which the respondent will not be able to pay for. And they realize that, and they're trying to cash out on all this. I don't care who gets what. Material is material. I can restart all over. All I ask is that this be made fair, and that they're unjust and blunt lies to the court, which have delayed my reunification and obviously affected their well-being, both physically and mentally, be supported by allowing the respondent to become responsible for some of the actions that she has caused during the last 2 years and some of the protection that her attorney continues to provide, all because of her financial interest in this matter. She stays here, she stands here claiming that she's going to forgive everything. Well, that's not the case. She continues to collect on me and has made no comment as to the outstanding attorney fees awarded to her. So to what effect does she want to run away from this matter after she has made all these lies and accusations to the court, and after I have recorded evidence and submitted it to them? This mother is going to continue to injure the children. I'm sorry, sir, go ahead.
Yeah, let me ask you a question, sir. I got from your response that you filed that you're not necessarily opposed to her withdrawal.
I'm not opposed to Erin's withdrawal. No, I am definitely not. I'm just opposed to her withdrawal expeditiously because it won't allow me the time to serve the rest of the paperwork or my children to be served properly during this process. I also do not oppose my son having an attorney, Your Honor. I really feel that somebody that I can speak with, rationally and like a regular human being, not being attacked by an attorney on the other side, would probably be helpful for this matter. What I don't agree with is her to try to retire, to try to remove herself less than the court rules allow, because I do plan on serving paperwork that will try to help the children and I continue to reunify in an effort to stabilize them. Your Honor, there is so much damage that has happened to my son in the last year, and the only influence is their mother and his mother and his grandmother, who is a noted racist and alcoholic. So I want to make sure that the court has this in mind to be able to make a decision that will please allow the better interests of the children to provide the care that they need and the access. Had I known that this matter would require declarations from others and not the paperwork that has already been submitted to the court, then that's probably something that I would have done in that week that the court has allowed me. But the timeliness of this is obviously fishy. Her wanting to withdraw, it's understandable. She's been put up against the wall with some of her previous actions. And, the run for these trust funds, I don't mind that she has the funds, but please consider that my children are being damaged by mother and that they need to be stabilized again.
In Your Honor, very brief reply.
Sure, go ahead.
Your Honor will have the medical records of the child. The child was in the ER for a heart condition after being told that he would have in-person contact at some point with his father. So a lot of these things that are put on mom or put on me, the court can read the counselor's records, the court can read the hospital records. They're all there for Your Honor to see. Again, this is why I'm withdrawing. Again, Mr. Gall makes this about me as the attorney. I have a real fear of what will happen should this case actually seek resolution. My client, when I say mental health, to attempt to make a mental health disorder from PTSD due to abuse, then suddenly a reason why, I'm not sure what the argument is. I'm just going to say this case has very little to do with me. The facts are the facts. They've already been, there is a DVPO. There is a re-upping of that DVPO. Mr. Gall has not seen his children. This has nothing to do with me as a person. This has nothing to do with me as an attorney. This is the facts of the case as I present them from my client's mouth. The money that's in that account, Mr. Gall has the ability to pay reunification and should have been paying it the entire time. Ms. Corey's here. She is the GAL. She was involved in this case throughout a lot of it. If Your Honor wants to hear from her, I'm sure she'd have no problem. This is a case where it is necessary for my client to be represented as a victim of violence. It is necessary for this child to be represented as a victim of violence. Unfortunately, at this point, my choice of withdrawal has nothing to do with money. I've already agreed to essentially write off $9,000, I believe is what it is now, more after today. It's not about the money for me. It's about my own personal protection and well-being. And so I would ask to be allowed to withdraw. I'd ask to be allowed to disperse $10,000 to my client so she can find counsel. I ask, and I think that counsel needs to be male for a number of reasons that I believe are borne out in the declarations. I also ask that Caleb be appointed court-appointed counsel, and again, that the trial be continued till June.
All right. Well, looking at again, I don't have the benefit of having heard all of the various back and forth between this case. I don't know if I've previously heard anything on this case that I recall specifically, at least. I have checked with court administration to take a look at what the week of the 22nd looks like, just so I had an idea of what we were looking at. The chances of a 3-day family law trial going out that week is probably slim to none, just simply because it's set behind, I think at this point, about 22, I believe is what she said, criminal matters. Obviously, there's not going to be 22 of those going to trial, but they bump civil cases during criminal week. So the chances of it going on the 22nd is pretty small. That doesn't mean it couldn't, but there's certainly no guarantee of that. And that was probably indicated at the time we set the second trial. Sometimes we do that in hopes that it'll clear up. Given the circumstances, it seems appropriate, probably for everybody's benefit, that Ms. Winkles be, excuse me, I apologize, withdraw from the case. I am inclined, given the relatively short time between now and the trial, if I had an attorney sitting here, that might be feasible to leave it on, but it's unlikely to happen. So what I'm inclined to do today is to, at this juncture, strike the trial the week of the 22nd. I can put it back on a trial assignment, see if we can get a time sooner than the June date. But again, it would likely be, well, it would be set as a second set behind criminal matters. So you'd be in the same boat.
I would appreciate that, Your Honor, please.
We can do that. I can set it on and pick another day, but I'm going to set it out a bit so that we, well, let me back up a little bit more here. I'm going to approve the $10,000 to be, well, frankly, I think that needs to be, we need to have an attorney on board before that's determined. So that needs to go directly as a retaining fee to an attorney. At this point, I'm inclined to put the balance of those fees, if Ms. Winkles is withdrawing, and she is, because I've approved that, those go into the registry of the court. Not inclined at this juncture to appoint counsel, but I would be inclined to appoint a guardian ad litem. I think, and if the guardian ad litem looks into the case and determines that is appropriate, representing 10 and 11-year-old kids is more of an art than a science. And it really depends on the minor and it depends on the attorney and whether that's going to be as effective as a guardian ad litem, frankly. So I guess my first two questions. It sounds like Ms. Corey previously worked on the protection order case.
That's correct, Your Honor.
And Commissioner Nelson transferred the protection order case to this case, Your Honor, because he realized it was being prolonged unnecessarily, that it should be.
My question is do you have an objection to Ms. Corey? And well, two things, Ms. Corey, I don't know if you'd be willing to take this case back on. Alternatively, do you have any objection to her coming in? She's got at least knowledge of the case, which would decrease the amount of time that would need to be spent by the guardian to kind of get up to speed. And her role really is to look out for the child's best interest. So,
I question, Ms. Corey, would you answer the court's question, please?
Ms. Corey, if you're willing, are you able to do that?
Yes.
Okay.
My only concern, Your Honor, is that Ms. Corey probably has not had as much communication with the children in the last year since she's been requesting to remove herself from this case as of the original rulings.
I understand that she's going to have some time to get back up to speed because if she comes in effective today, then we're obviously not going to trial on the 22nd. So she's going to have some time to look into the matter. And then she also could be present at a trial assignment to determine kind of what timeline she thinks she needs to get up to speed. And I think I'd like to have her talk to the child to determine whether or not in her mind as the child's advocate, whether an attorney makes sense. It very well may, but it's difficult with children of that age. That's a very, that's right at the age where we start looking at appointing counsel. And I think depending on the maturity of the child, it may be more effective to have a guardian ad litem as opposed to an attorney. Attorneys representing kids of that age are kind of put into a Hobson's choice of how they handle the case, because it's on one hand, they're sort of acting as a guardian ad litem, and the other hand, they're supposed to be representing the interests of an 11-year-old.
Yeah.
So
I definitely agree with Ms. Corey coming in, Your Honor.
All right. So let's start with that. Ms. Corey, I'll appoint you. And I don't know, do you recall how your fees were paid the last time?
They were split half and half between mother and father.
And
Your Honor,
my clients were paid by county pay.
Your Honor, would the court please consider paying additional fees out of the remaining funds?
At this juncture, I'm not going to do that. That money's going to go into trust, and if it determines we need to have an attorney appointed, we may need some funding for that. Again, you've requested some money for this visit, the reunification counseling. I don't know enough about the case to understand what the current orders are as it relates to that. And I guess I'd want to know more about that before I made a decision. So that money would just simply go into the registry of the court. And if we determine down the line a bit that that's an appropriate use of those funds for either of those things, then we'll certainly consider that. But at this juncture, I'll enter an order appointing Ms. Corey under the same terms as the last order.
And Your Honor, if I just to be clear for me, since it's dealing with my trust account, I'm to disperse 10,000 when Miss Gall has counsel, and the rest of the money I'm to be putting into the court registry. Is that correct?
That is correct.
Okay.
Would Your Honor please order Ms. Winkles to provide proof of that distribution when completed, please?
I think it's appropriate to provide documentation that the transfers have all been completed. Sure.
Okay.
Absolutely.
And that can be filed under seal as a financial document with the court, I think, and copy, of course, to Mr. Gall.
One last thing, Your Honor. Part of what I've been fighting is a financial attack from both mother and her attorney. They've had prolonged events and extended things and regressed on progress. I am currently paying $1,100 a month in child support, which is current, contrary to Ms. Winkle's statement. And that actually leaves me at a negative $600 a month after my mortgage. All of my financial statements are made public to the court.
Okay, well, let me stop you right there. I'll be happy to take a look at those orders, but I need to have it done by a proper motion with supporting documents as far as finances and expenses and things.
To that effect, Your Honor, would you?
If you want to file that, I'll certainly take a look at it.
Absolutely, I will file, Your Honor. But to that effect, would Your Honor please allow me to file and serve the respondent by email, just like I'm being served by email currently?
And I would object. We also serve by hard copy.
As long as we have an address where that can be served at.
So the respondent is 2.5 hours away, Your Honor.
Well, you could do it by mail, or there's a lot of ways that can be done. Mail is an appropriate service. It just adds a few days time to the
Register mail, okay.
Yeah,
okay.
So, but yeah, she does need to be personally served unless there's an agreement otherwise. I think what I'm going to do as far as a trial assignment, my thought on this is I'm going to do this today. I don't know, Ms. Winkles, do you have any thoughts on how soon you'll be able to find an attorney? It wouldn't be done through the court, obviously, but.
No, I've already contacted 3 attorneys for Mrs. Gall. I hope to hear back today from some of them. So I asked to put this out 3 weeks. That should give that person enough time. Hopefully we can find somebody by that point.
And Ms. Corey, do you think you'd have an opportunity to speak with the child prior to 3 weeks from now? Assuming that's connections can be made?
Yes.
Okay, so let's put it on for the 24th. That's 3 weeks from tomorrow, Wednesday docket at 1 o'clock. And Ms. Corey, if you would be able to let us know prior to that docket or even at that docket whether or not you think it's appropriate to appoint an attorney, we could consider that at that time.
Can one of you give me the RCW with the points about a child having an attorney?
I can do that, Your Honor.
I'm not sure there's not a whole lot of specifics. It's whether you think it's going to be appropriate and useful to have an attorney representing as opposed to a guardian.
Okay.
It depends on the maturity level of the child. Real hard to represent a 2-year-old's wishes in court. And as they get 11 and older, it starts to become more of a doable thing.
Okay.
All right, so put it on, and I said the 24th at 1 o'clock. That'll be a Zoom trial assignment docket. And then we'll, I think that was everything that I can actually address today.
It was. Now orders, can we do presentation relatively quickly, just given the withdrawal?
You can, I believe. Let me just double check something here. I have to look at the calendar now because I have a new calendar and I'm not sure exactly what I'm doing when. How about, can you do it by this Friday?
I can, yes.
That'd be an 8:45 Zoom on my regular presentation docket. It's on our Friday calendar, or the link on that.
Your Honor, I'm not available Friday in the mornings. I'm traveling at that time.
Well, I could do the 12th.
I'm available the 12th, Your Honor.
And that works for me as well.
That's probably a little more realistic anyway. So we'll set it at 8:45 on the 12th. It's a Zoom hearing. To find the link for that, you go to our court website and the schedule will say Judge Basher's presentation docket at 8:45. And if you get those documents, sir, and they meet with your approval as to what they say, not whether you agree with what I ordered, but if they say what I ordered, you're certainly welcome to sign off on those, and then you wouldn't have to be at that hearing. It's up to you, though. Okay.
Understood. Thank you, Your Honor.
Right. Thank you, Your Honor.
12th at 8:45.
Okay.
All right, and we'll await order. All right, are we on the record? All right, thank you. Looks like we're on the record. And let me see here. I think I see Ms. Winkles, you're not able to use audio.
I can use audio or video, but not both because I'm on a cellular thing. Unfortunately, my internet's down.
All right, audio is fine. I see Mr. Gall logged in. Mr. Gall, did you have a chance to take a look at the proposed orders?
I did, Your Honor. I got them late last night and they were, I'm surprised. They just lacked some clarity per our last hearing. I just requested less than an hour ago for the respondent's attorney to clarify those things, but I haven't heard back from her yet.
Yeah, unfortunately, I don't have internet at the office at all. So I'm working off my cell phone. I don't mind any oral opposition or anything like that, just because I can't access anything.
Okay, perfect. Let me just read them out loud so that they can, for your consideration, see if they can go on the record. Give me a second.
I did note one correction. The trial scheduling date is the 24th, not the 22nd. So I have made that correction.
Perfect. So I just wanted to make sure that the funds, the $10,000 that are being awarded for additional representation are to be distributed to the new attorney after the new attorney has made themselves available. This was specified by Judge Basher.
And I agree with that, Your Honor. I noticed that after it went out.
Number two.
Here, hold on just a second.
It's the one on the very, if I remember correctly, it's on the first page at the very bottom or the second page at the top.
Right, I see that. How about if I just add at the end of that 10,000 directly to the attorney referenced in number 7?
I'm okay with that.
Okay. I think that'll.
My second request, if I may.
Sure.
Okay. Is it states that I can serve the respondent, but I would like it to say that I was advised that I can also serve her by mail, which is important for me because of her distance.
And my only caveat to that, Your Honor, is if it's a contempt motion or any petition, it would need to be served personally. That's why I put proper service. But obviously on service of motions, it's, it is proper service on
Right.
mail.
Right. Mail is fine as long as it's within this case. If you were to start a new case or something like that, it would have to be by personal service. But anything served and filed in this current case can clearly be done by mail.
Thank you, Your Honor. The last one is in our last hearing, I had requested the court to consider some funds for reunification. Judge Basher had denied that request, but had left it open for me to make an official request with the proper paperwork, because apparently I didn't submit the right paperwork during my response. And so I just want to make sure that that's coming. That's all.
You would just simply need to file a motion requesting that with some documentation for it.
Okay, perfect. And those are all the changes I have, or clarifications.
Okay, then I will go ahead and sign these with those changes. I changed it's paragraph number 11 where it says universal trial docket. That said January 22nd. I've changed that to the 24th.
Okay.
Which is that is the trial assignment docket. So
And absolutely my fault again. My legal assistant was not able to review these because of the internet issue. So my apologies.
Yeah, that one. I only know because the 22nd is stuck in my head for other reasons. That's a Monday, so we've got that taken care of. Just 1 second here. Today is 12.
Your Honor,
I did also notice it appears they struck the June trial and not the January trial. I'm not sure if that was an oversight or if that was meant to happen. I know that this is going back on to find if there was something earlier than that.
No, that shouldn't be. Yeah, that shouldn't have been stricken. So for my clerk, if we can double check that, the trial that was previously set in, I think, what was it? Do you remember the date, counsel?
I don't, but it was civil priority week.
June 18th.
June 18th. That should not have been stricken. The one for the 22nd is the one that should have been stricken. So if we can double check that on our record, we'll get that fixed. All right, so sign that order. Sign the appointment of Ms. Corey. So that should take care of this case until you come back on the 24th for a new date.
Thank you, Your Honor.
Thank you, Your Honor.
You're welcome. Have a good day, and we'll talk to you later.
Bye-bye.
Thank you.
Mr. Gall, can you hear us? You're still, there we go.
Yes, I can hear you.
All right, so this was set over to review compliance on some discovery. It sounds like that has not been completed. Is that accurate?
Compliance on discovery? No, Your Honor. To be honest, I'm surprised about this hearing. My understanding from the guardian ad litem is that she was to give you an update on her efforts with their reports, which is Ms. Corey. So
Your Honor, this is not the,
That's a different case.
Hey,
yeah, this is a different matter, Your Honor.
Counsel, please don't interrupt when someone else is talking. Go ahead, Mr. Gall. I couldn't hear what you were saying.
So Ms. Corey is here to give the court an update of what's going on. I had no clue that there was a discovery issue at all, Your Honor.
All right, well, Ms. Corey had indicated that this would just be over a week due to some issues, which is fine on that issue.
Yes.
When we were here last, which was, just a second here, on the 6th, we set it over to today on the motion to compel because there was some information that you were going to provide at the end of last week.
Yes, Your Honor. I'm actually still waiting for Ms. Corey's report and the reunification counselor's report as well to submit for that, Your Honor. So that all that information is not yet complete for me to present to the court. And to be honest, Your Honor, Commissioner Kearney made it sound like that I needed to reapply for that hearing and that she was not going to allow for what you are mentioning to be heard. And I'm very happy that it is allowed to be heard. But I'm still waiting for information from the reunification counselor to submit to the court. There's been some drastic changes, and apparently, Your Honor, the guardian ad litem was supposed to provide you an update with their efforts, and there's a medical emergency with the children.
I understand that, sir. This is a separate issue. This has to do with the discovery request that we were on, I believe, on the 6th, from a motion to compel discovery.
Your Honor, if I may interject, Mr. Call is not the respondent in the motion to compel. That would be Mr. Fowler.
I'm sorry. Thank you. All right. So is Mr. I apologize. I was got the wrong thing. So just hold on a second, Mr. Gall.
Understood.
All right. So Mr. Gall, I'm gonna come back to you real quick. Ms. Corey did appear indicating there was a medical emergency and we were going to set this over to next week, and apologize. I was a little confused earlier. I was looking at the wrong.
No worries.
So we'll just put it over to the 20th at 1 o'clock.
Thank you, Your Honor. And Your Honor, may I ask, I don't know how the court notifies people, but I provided my email and my address. How can I be made aware of these hearings? Because I was not aware of today's hearings, Your Honor.
This one was noted on the order appointing guardian ad litem.
Got it. So I must have hung up too early, Ms. Corey?
Now, if you look on the order appointing Ms. Corey, there should be 3 dates on there. Today was the first one of those days, and we're setting today over to next week. There should be 2 more dates on that order.
Correct. And then the final due date is the 20-something of April, correct, Your Honor?
I don't have that in front of me, but I believe so.
Okay. And yes, Your Honor, to be honest with you, I was a little disheartened when Commissioner Kearney disallowed my rescheduling of a faster trial date, noting that I didn't have good cause. And
I understand, sir, that you can address that at a different time. This is not the time for that.
All right. I was just addressing the confusion, Your Honor, so thank you.
Okay.
All right.
That's all for today. We'll see you next week.
Okay. Bye-bye.
All right. Then I believe we have, there was one that was a couple of compliance reviews. Do this real quickly. Gall and Gall. 22-3-8108. And let me see here. Miss Corey, did we have, you heard from the parties?
And after lunch.
Yeah, would you bring it?
Pardon me, Your
Here,
Honor,
and
I
I'll go
can't-
over it with you.
there's someone talking.
A
Couldn't
second.
hear you.
You did. Okay. So in the Gall and Gall matter, have the parties contacted you?
Yes, I've
Okay.
been in contact with both parties. However, in this particular case, even though the kiddos live out of town, pretty substantially out of town, I feel the need to visit them in person rather than by Zoom. It's difficult with children over Zoom. And I actually have that planned for later this week.
Okay.
Ms. Gall is county pay. Mr. Gall is private pay, I believe. Have not seen any payment as of yet, but really haven't had that discussion with him. So,
Okay. And but you've been in touch with both parties at this juncture?
yeah.
Okay. All right. So, Mr. Gall, you need to work out that issue with the guardian and get that taken care of.
Yes, Your Honor.
Let me see here if I've got, I think we have, that was really, I think all that was on for today was to make sure everybody was in touch with you. And we've got a review hearing on March 26th for an interim report. So hopefully that'll be sufficient time for you.
Yes, I hope so.
Okay.
Thank
All
you.
right. All right. So I think that's all for today. And then we'll see you back on the 26th unless we hear something else.
Thank you, Your Honor.
Thank you.
Thank you.
On the Roberto Gall and Jesse Gall matter? Anybody here on that one?
I'm here, Your Honor.
Good afternoon.
I realize that doesn't fully answer your question. For purposes of the court, my name is Kevin Curtin. I'm an attorney here on the Gall v. Gall matter. I represent the respondent, Jesse M. Gall. I filed a notice of appearance. I had to mail it because I'm in King County. I mailed a notice of appearance, and my understanding is it made it into the court file yesterday. I also sent a copy to the opposing party, Mr. Gall. Today, I sent a copy to Ms. Looney, who works for the state, and Ms. Corey, who is the GAL. So I believe everybody has at least received a notice of appearance.
Okay, and I do see your name. I do see your name here, so apparently we got it filed. So,
And Mr. Curtin, there is one more person you may want to notify, and that is Ms. Charlotte Rosen. She's the
Ms. Rosen, yes.
Yeah.
I went to Ms. Rosen's website today to try and get an email address. I couldn't get an email address to send it to her. I left a call and a voicemail, and I'll be checking that after this hearing, but I assume she'll direct me to either fax it or email it to her today, and I'll take care of that this afternoon.
I'm happy to help introduce you, sir, and welcome to this matter.
okay. So this was, I believe, just on for a GAL interim report, which I have received. See, Ms. Corey is present. So I think that really today was to put that on. It says, I don't know, I'm not sure why it's saying review temporary orders because I don't see any motion in the file for today.
There are no motions, Your Honor. Your Honor had granted me the ability to explore the option of requesting a lower child support because of the financial strains I'm experiencing. But Commissioner Kearney denied me after you had scheduled me, Your Honor. So I'm not sure what motions would be in place.
Okay, well, there is, like I said, there's a guardian ad litem report that I think I need a motion if I'm going to move forward on that today. I typically just come on for review to make sure that they're done, and that if additional time is needed, it looks like Ms. Corey got it done timely. Thank you. So at this point, unless someone files a motion, I don't have anything else on this case today. I know that there are some concerns in the report. So that's probably be appropriate to look at that.
I do have a few items to discuss, Your Honor. It turns out that when we selected Ms. Corey again, I may have logged off the call too soon. It had taken me some time to ask my employer for an advance to pay her fees. And my employer finally granted me an advance to pay her fees. But as it turns out, I was not aware that her fees had increased. It was my impression that her fees were the same as the last time. the first time around, which were $750. I had a hard time attaining that amount. And finally, my boss allowed me to borrow it. I forwarded that amount to her. And last week, Miss Corey contacted me. She said that her fee schedule has changed, unbeknownst to me. It's probably my fault for not having an attorney or having the money to have an attorney. But I was not aware that her fees had increased to $3,300 and that I was responsible for half of that or something to that effect or around those. Miss Corey, can you specify?
Well, I'm just looking at the order that's in the file. Which it looks like it'd be 1485, is that?
Yeah, so that for some reason that completely escaped me, and I don't know how, Your Honor. I'm currently recovering from being ill. My request, Your Honor, is I was wondering, is it possible for the court to allow the remaining balance, which is like $735, I believe? Would the court please consider paying that from the funds that are in escrow with the court so that Ms. Corey can be made current with the fees? I asked Ms. Corey if she would take a credit card and she does not take credit. There's just no other way.
Well, first off, before I make any, I don't know enough about all the finances in the case to make that decision today. If you wanted to file a motion, I certainly can take a look at it, but that both parties need to be able to see that motion and understand it.
Got it.
But you're certainly welcome to note it on. I'd be happy to look at it.
Okay.
And at this point, we're not stopping the case because you owe some money at this point, obviously.
Yeah.
And we'll work through that. That will need to be taken care of unless we make some different orders. So.
Understood.
Okay.
Thank you.
All right. Anything else today on this one?
If I may, Your Honor,
yes.
Just a few minutes of the court's time. Sure. If I could, does the court's bailiff have an email address that I can use when I'm trying to communicate with the court? And I'm asking because, like I said, I'm situated in King County, and when I mailed my notice of appearance, it took a week to get from Seattle to the court. And this is set for trial in June. We're not going to be moving forward on anything with the GAL report today because she didn't have any recommendations yet. So there's nothing to be addressed there as far as I can tell today. The court's temporary order that was issued on January 12th, it appears that it appoints the GAL and everything else appears to be up to date. I think everybody's in compliance with the order that was issued on January 12th of 2024 in terms of Ms. Wickles' notice of withdrawal, my notice of appearance, how to set up the GAL. The GAL was ordered. So I don't know that there's any temporary orders where there's any issues remaining with the temporary orders, but in case I want to communicate with the court, something faster than postal mail would be helpful. And also I noted in my court, I know in an abundance of caution, I wrote in my notice of appearance that I would not be able to make physical appearances and that I would be requesting that everything be handled by Zoom. I realize that's the court's normal practice, but I just wanted to be clear on that personally, because I don't want to delay anything in this case. It's a 2-year-old case already, and I'm sure we don't want unnecessary continuances because I was not fully informed about the court practices. So I just wanted to verify that as well.
No, you're fine. I recall that question having come in myself, and we did understand that this would be a Zoom case essentially, which is fine. Is it just 1 second? It's just Superior Court Administration? Yeah, so if you just send an email, if you go to our website and go to the administration tab under contact us, it's got our court administrator as well as other staff.
Okay.
But you can also send an email to Superior Court Administration, all one word, at cowlitz.gov, just our email addresses. And that gets to all of our staff. So if you have questions or something, but if you go to the contact us on our website, it's got all that information, how to get a hold of us. And
Understood.
So you can get your questions answered. And then if you do need to get something quickly, they can give you some instructions how to do that.
I appreciate that, Your Honor. I have one last question. Sure. I noticed it doesn't appear that there's a protection order case that's separate from this, and it doesn't appear that those cases were in any way consolidated. Is that something the court would want to consider? Because one's going to impact on the other, and it seems more sensible to try and address them both on the same calendar at the same time. It avoids multiple appearances from the parties, et cetera. But if consolidation is not in the picture, then we can do it on a bifurcated basis. But since any findings of one might impact the other, I thought maybe consolidating the two of them might be wise at this point.
Just from a process standpoint, we generally don't consolidate two different types of case numbers, one's civil, one's domestic. They can be related to one another, but they're typically done separately. You may want to contact the court clerk to see what their position on that, because they're the ones who manage all of that, although we would make those orders if in fact they were okay with doing that.
Understood.
Yeah, normally that's it. They don't consolidate two different case types, like a 1 and 2.
I understand.
Okay.
I have no other questions at this time.
Your Honor, if I may just provide some background for Mr. Curtin in regards to that question.
I'm gonna let you guys do that offline because we have other people waiting for court. So
Understood, Your Honor. Thank you.
okay. All right. And you feel free, you can email each other all you want to on your own time.
Yeah, it's been a breath of fresh air. Thank you, Your Honor.
Okay. All right. So that should be all for today. Let me just double check and make sure. I know we have some other hearings set in this case at some point. It's like,
would it be possible for me to just, and again, it's because, hey, I'm practicing remotely and I don't see a way for me to be able to find this online. So could I just verify verbally now the next couple of court appearances so that I make sure I don't miss any deadlines?
That's what I was going to do right now. I show a review hearing for a final guardian report on April 23rd.
Okay.
That'd be on this docket at 1 o'clock. I show a May 28th readiness hearing, which would be 11:30 in the morning. That's a readiness. It'll be on our website. You can go to our Zoom hearings and it'll have a link to it.
Okay.
And then on June 3rd, I have it set for a 3-day trial. So that's what's currently scheduled. If you do have access to Odyssey portal, you should be able to, because we're an Odyssey court, so you should be able to access anything from our court file that you can access on any Odyssey court.
Perfect. I will try that. And thank you for verifying those dates, Your Honor. I appreciate it.
All right. Anything else today?
Thank you, Your Honor.
Okay. Thank you, Ms. Corey.